Good afternoon. Today is Monday, September 13th, 2021, and this is a meeting of the Virginia Redistricting Commission. I'm Greta Harris, co-chair of the commission, and will be presiding over this meeting. I want to remind members, staff, and other speakers on today's meeting of a couple of items. First, please keep your microphone muted until you are ready to speak. This improves the quality of the audio for the meeting. Before you speak, remember to unmute yourself. Also, please remember to state your name before speaking, especially before making a motion. This helps us in keeping track of what is happening. Voting. Any votes taken will be done by voice. Staff will call the roll for each vote taken. Registration for virtual public comment has closed. We do have individuals who signed up to virtually provide public comment. Any individuals who would like to provide public comment in person at the full commission meeting may do so. We appreciate the public's participation. Such comment will be limited to 2 minutes at the discretion of the chair. I also note that members of the public who wish to comment on an agenda item may also do that by sending in an email to varedist@dls.virginia.gov. The comment will be posted on the division's website at virginiaredistricting.org. Again, for members of the public who would like to comment on today's meeting, the email address is varedist@dls.virginia.gov. Who will be calling the roll call? Okay, Claire, if you could do that, please. Thank you.
Mr. Abrinio,
Present.
Mr. Feliciano,
Present.
Mr. Harrell,
Here.
Mr. Hutchins,
Here.
Mr. Kumar,
Here.
Ms. Thornton, Delegate Adams,
Here.
Senator Barker, Senator Locke, Senator McDougall, Delegate McQuinn, Delegate Ranson,
Here.
Senator Stanley,
Here.
Delegate Simon,
Here.
Ms. Babachenko,
Here.
Ms. Harris.
Here.
Madam Chair, you have a quorum.
Thank you so much, Claire. I think as everyone knows, the Virginia Redistricting Commission is something that's brand new in the Commonwealth of Virginia. And so as we have been building the plane as we're flying it here, we know that there will be changes and improvements along the way. And today is no exception for this being an iterative process. And so before we get started, I just want to thank the public that has been a partner with us as we have gone through this very important process. We have gotten thousands of comments via email, on the website, handwritten notes, and actual verbal comments. And we appreciate that as a commission and encourage the public to continue to do so as you go down this path with us. We also want to thank the Division of Legislative Services staff. They have been incredible in supporting the commission. And although we have lots of public meetings here, these guys are working before and after every meeting, and we are just appreciative. We make lots of requests, and they generally are able to accommodate those requests, i.e. we have water and snacks in the breakout room for members of the commission, so please help yourself. We appreciate that. We also want to thank the variety of consultants, legal, communications and outreach, technical map drawers, who are bringing their lived experiences and expertise to help the commission in making the best decisions that we can. And then I would also just like to thank my fellow commissioner members that may come from different parts of the state, have different lived experiences, different perspectives on lots of different things that are facing the Commonwealth of Virginia. But the one thing that we have that is shared is our love of the Commonwealth and our desire to have fair maps as we go forward for the next decade. So this partnership continues to unfold and get better tomorrow than we are today. And we are just appreciative of everyone's willingness to pitch in as we do new maps for the state. So after last week's meeting, my co-chair and I, along with legal counsel and DLS staff, met to sort of reassess. We do that after every public meeting. And we were concerned around the timing that is statutorily laid out for us, that we were not going to be able to get through the large swath of land that makes up the Commonwealth of Virginia in the way we were doing it by regions. And because when you do one region, it has ripple effects to adjacent regions. After council, consultation, we decided to try something different. And so we're going to be looking next Monday, the 20th of September, at proposed maps, two different ones, both for the Senate and the House for the entire state of Virginia. And in order to do that, we as a commission have to give more guidance to the map drawers as they go about their business of presenting proposed maps to us. So there are 3 layers of guidance or input that we will have. The first one is the criteria that the commission voted on a month or 2 ago, which really laid out broad priorities that we wanted to consider as we were drawing new maps for the Commonwealth. Today, we're going to begin the process of getting more granular and giving specific guidance to the map drawers on some really important pieces that I think we'll probably have a variety of different opinions on. We will be taking votes to try to narrow down the direction. And specifically, we'll be learning more about more details of the Voting Rights Act, political subdivisions, communities of interest, and partisan equity. And we will hear from both legal counsels in just a few minutes because over the weekend they worked together to present more specific guidance that is needed and that the commission will need to decide upon. The third layer of input to the map drawers will be the public comments. And we have, again, received thousands of comments, and we now have a consultant on board who is sorting through all of those comments. And on, is it Wednesday? Is that when we meet again? Wednesday afternoon, those consultants will be giving a presentation of at least a portion of the state because of the timing to get the technology up and working. They may not have the entire state, but we'll be able to look by region and sort the hundreds and hundreds of comments and be able to lift up what are the most relevant comments to take into consideration that the commission will then instruct the map drawers to consider as they're doing their maps. So we have the criteria that we've already voted upon. Today, we're going to start getting into more specific guidance around those 4 buckets of details for the map drawers. And then Wednesday, we'll begin to hear sorted public comments that we can also take into consideration for guidance to the map drawer. So the partnership continues with all of those parties working in concert with one another to have fair maps at the end of this process. So I will stop for a second to see if there are any questions from members of the commission on what we're doing now. This is a pretty significant pivot from what we were doing just a few days ago. Any questions? Okay. Well, if not, I'm going to ask our legal counsel to begin their presentation. This memo that has been drafted by both legal counsels, or all legal counsels, has been posted on the redistricting website, so members of the public can begin that. And I would ask that we start in the order that's on the agenda with the Voting Rights Act. And I believe, Mr. Hebert, you're going to kick us off, and thank you so much for your work over the weekend to get this done.
Thank you, Madam Chair. And thank you, Mr. Bartolucci, for letting me go first. I want to start by talking a little bit generally about Section 2 of the Voting Rights Act. Section 2 is a federal statute, first enacted in 1965 and then amended several times afterwards, most recently in 1982. It is a nationwide provision, and what it essentially says in the Voting Rights Act is that it prohibits what's referred to as minority vote dilution, which, as you'll see in the memo, is either the minimizing or canceling out of minority voting strength. And by minority, I'm referring to what is a protected minority group under the Voting Rights Act, a racial or language minority group whose members are specifically referenced. Section 2A of the Voting Rights Act prohibits any electoral practice or procedure that results, and that's an important word, in a denial or abridgment of the right of any citizen to vote on account of race, color, or membership in a language minority group. Now, I say results is important because 1982 amendments to the Voting Rights Act inserted that word to deal with a case that had come out in 1980 called City of Mobile versus Bolden, in which the Supreme Court had said that to prove a violation of minority vote dilution or the Voting Rights Act under Section 2, you had to prove intentional discrimination. And previously it had been thought by many that you only needed to show discriminatory results or impact. And so Congress amended the act in 1982 to make clear that results alone and not intent constitute a violation of Section 2 when certain circumstances are met. Now, I will concede at the outset, and the good part about the memo that we have is that I believe that as to pages all the way through page 7, we have agreed on that language. You'll see that we give a background of the Section 2, and then we say, in redistricting, the law, Section 2, poses the following question: when and how must a state or a commission draw district lines to avoid diluting the voting power of a protected minority group or groups? Or, sometimes more specifically, when must a state create majority-minority districts? That is, districts in which minority group constitutes an effective voting majority. And I should stop there by saying that effective voting majority means that the minority voters in that district have the opportunity to elect their candidate of choice, notwithstanding how anybody else votes in the district. Sometimes also called as the minority group's preferred candidate of choice. Now, as you probably have noted, Section 2 on its face doesn't really provide much of a clear answer as to how to avoid vote dilution. And in 1986, the Supreme Court, in a case called Thornburg v. Jingles out of North Carolina, which involved multi-member legislative districts, the Supreme Court articulated a framework in how to go about measuring minority vote dilution. And it said that in determining, the first step in determining whether a majority-minority district must be created under Section 2 asks 3 questions. 1, is the minority group, quote, sufficiently large and geographically compact to constitute a majority in a single-member district? And the other 2 parts, 2 and 3, are flip sides of the same issue. Is the minority group politically cohesive? That is, do they vote together to enable it to elect their preferred candidate? And the third factor is the flip side of that. Does the white majority vote, quote, sufficiently as a block to enable it, in the absence of special circumstances, usually to defeat the minority's preferred candidate. Those are known as the three jingles factors in the law, or the three jingles preconditions to whether you can prevail if you file a Section 2 lawsuit. And if the answer to any of those three questions is no, then Section 2 does not require the state to create a majority-minority district. Now, I have in there another paragraph, we have another paragraph talking about explaining how those might constitute a no answer. So just to give one example, if the minority group is not sufficiently large and geographically compact to constitute a majority in a single-member district, a hypothetical demonstrative district, then what that means is that the minority group could not have constituted an effective voting majority under any reasonably drawn alternative plan. And therefore, the minority voters' preferences in that district could simply never be satisfied. So those are the kinds of illustrations that follow on the bottom of page 3. Now, those three factors alone do not complete what federal courts have looked at to determine whether Section 2 is violated or complied with. Because even if the answer to all three jingles questions is yes, then the court must determine whether, under the, quote, totality of the circumstances, close quote, the minority group has less opportunity than whites to participate in the political process and to elect candidates of its choice. So we might say that the three jingles factors now have a fourth factor, which is that courts must determine whether the totality of circumstances justifies the creation of an effective district for minorities. And only when those four factors are met must a minority opportunity district be created. That's language right out of our memo on page 4. Now, courts have considered a wide variety of circumstances in making this totality determination, and they are listed actually in a Senate report, which is footnote 12, that accompanied the 1982 amendments to the Voting Rights Act. And you'll see there that, and I won't go through all of it, but is there a long history of discrimination against minorities? That's one factor under the totality of circumstances. Is there a slating process if it's a local election, say? Are minority candidates denied access? Do minority groups suffer the continuing effects of past discrimination in areas of health, education, housing, et cetera? Those sociological factors can come into play because they, after all, affect the minority community's ability to cast ballots and to participate effectively in the political process. So that's that fourth factor. Now, another case that came along in 1994, and I should say that this is a trip down memory lane for me because City of Mobile v. Bolden in 1980 was a case I worked on, and Thornburg v. Jingles was a case that I worked on. This is all while I was in the Justice Department. And Johnson v. DeGrande, the third Supreme Court case I'm about to discuss, was another case that I tried in Florida. And in that case, the Supreme Court analyzed another factor called proportionality. This kind of comes at the end of the map drawing process in a way, or towards the end, not at the very end. The court assumed in DeGrande that all three jingles factors had been satisfied, and yet it rejected the plaintiff's Section 2 claim. And it did so by explaining that the totality of circumstances factor, number 4, that factor did not support a finding of dilution because the minority group constituted an effective voting majority in a number of districts that were substantially proportional to their share of the population. I won't go into the details there, but essentially the way that the case was framed below was there was an attack on the failure to create majority Hispanic districts in the Miami-Dade region. and that's the way the claim was framed in the complaint. And Cuban Hispanic voters in that region did have effective proportional representation in that area, and the court noted that if the claim of lack of proportionality had been framed as statewide, well, that might have been a different situation. But because it was framed in terms of South Florida, then the court said that that's a factor that means the plaintiffs lose. And I'll quote a couple of pieces of that decision just so you can see where the court came down. This is all still good case law, by the way. Section 2 does not mandate that a state create the maximum number of majority-minority districts. And then I haven't reached the quote yet, and that's at the court's decision at page 1020. And then it says, although rough proportionality does not automatically protect the state from liability under Section 2, in other words, if your plan provides proportional representation, you still could be found violative of Section 2. It is a strong indication, however, that if you have proportional representation of minorities statewide, that minority voters have an equal opportunity, in spite of racially polarized voting and in spite of white bloc voting, to participate in the political process and elect candidates of their choice. And Justice O'Connor filed a separate opinion in that case saying proportionality is always relevant evidence, but it's never by itself dispositive. And this is, again, language that we've put together for you that all of us have agreed on. Now, although these cases do provide you with a pretty good framework for analyzing potential Section 2 issues, many issues remain unresolved, and that's the part that we want to take up next. And in fact, this is a difficult area to cite lower court cases because, frankly, they're all over the place. Some of them are even different and provide conflicting answers to many of the questions. So the first question we thought we would pose is, what constitutes a majority under Jingles prong 1? And the first prong asks whether, as I said earlier, is the minority group sufficiently large to constitute a majority in a district?
Madam Chair, could he tell us what page he's on as he goes through this, just to make sure we're all following?
Okay, thank you.
Thank you, and I apologize for not doing so, Senator. It is page 5 I'm on now at the top, or the middle, actually, what constitutes a majority. And the Jingles Court didn't really use that language throughout its opinion. Instead, it kept repeatedly referring to whether the minority group is an effective voting majority. So as a result of that, there has been some disagreement among the lower courts as to the proper definition of majority for purposes of meeting Jingles prong 1. Can a group, for example, constitute an effective voting majority even if it accounts for less than 50% of the population in the district? Conversely, can a minority group account for more than 50% of the population in a district and still not be able to constitute an effective voting majority capable of electing their preferred candidate over the opposition of white voters? Now, the court answered the first question in a case called Bartlett versus Strickland, resolving a question that really had divided a lot of the lower courts. The court held that in order to satisfy the first Jingles factor, a minority group must constitute more than 50% of the voting age population in a proposed majority minority district. Now, the court went on. The court was concerned with coming up with a standard that lower courts could easily follow. The Supreme Court likes bright line tests, and they feel lower courts, if they can provide one, would make it more judicially manageable. And so the court held that Section 2 of the Voting Rights Act requires that minority voters must make up more than 50% of the BAP, voting age population in the district, to qualify as a group capable of electing a candidate of their choice under Jingles prong 1. Now note, and this is important, and we're going to talk about this, I suspect, a lot today, that this is a case where this language talks about where if you are proving a Section 2 violation in a case, I file a lawsuit challenging the failure to create a majority-minority district, I have to be able to show that the minority group that I'm advocating should have a new district, that they are at least 50% of the voting age population in that district to get over prong one. That prong 1, 2, and 3, basically in the law, create what's called a prima facie case that at least you can avoid a motion to dismiss, so you're going to get at least far enough down the road. The court went on, Justice Kennedy, writing the majority 5-4 opinion, said that majority-minority rule relies on an objective numerical test. This is at the bottom of 5. Do minorities make up more than 50% of the voting age population in the relevant geographic area? This rule provides straightforward guidance to courts and to those officials charged with drawing district lines to comply with Section 2. Now, we have at the top of page 6, we have some further explanations that we've both sides have come up with that says that as a result, if a minority group constitutes less than 50% of the population in a hypothetical demonstrative district, then the plaintiffs cannot prevail on a Section 2 claim, even if the group would be able to regularly elect the candidate of their choice with the reliable support of crossover white voters. So under Bartlett, while legislators remain permitted to draw districts, what we call crossover districts, sometimes called coalition districts, they are not required by the Voting Rights Act to do so. Bartlett made clear that a numerical majority is a necessary condition for satisfying Jingles prong 1. But it did not resolve the question of how much beyond a mere numerical majority-minority must a district be in order to provide minority voters with an opportunity to elect their candidate of choice. And then we have a sentence that says, if, for example, white voters are more cohesive, politically cohesive than black voters, then the threshold for an effective majority for black voters could be substantially greater than 50%. As one court explained, an opportunity district is one in which a black majority has a practical opportunity to elect the candidates of its choice, and that a simple majority is not always sufficient to provide this opportunity. And then we have a paragraph that talks about something called influence districts, which was at issue in a case in the Supreme Court of the United States called Lulac v. Perry, a case I handled. And in that case, the Supreme Court found that influence districts are not required by Section 2 of the Voting Rights Act. An influence district is a district where a minority group, although too small to control the outcome of an election, is of sufficient size that they could actually influence the policy of the district in some way, or influence the representatives who ultimately gets elected from the district. In the case of Lulac v. Perry, there was a district in East Texas that was majority white, and minorities constituted a 20% portion of the district, and the district was extremely competitive politically between Republicans and Democrats. A Democrat kept getting elected only because the black voters voted overwhelmingly for the Democratic candidate, and even though white voters split their votes among Democrats and Republicans, the white Democrat got elected. And that was the argument was that black voters, even though they were only 20% or so of the district, that they had influence, and the Supreme Court rejected that argument in that case. The court found that, quote, while the presence of districts where minority voters may not be able to elect the candidate of choice, but can still play a substantial, if not decisive, role in the electoral process, may be relevant under Section 5 of the Voting Rights Act, which is a whole other section that you don't have to worry about in terms of federal law. The lack of such districts, the lack of an influence district, cannot establish a Section 2 violation. Any questions before I move on? I'm going to now hit the middle of page 6 and talk about compactness.
Madam Chair?
Yes?
Yes, Delegate Simon.
So since you, I wasn't going to interrupt, but since you asked for questions at this point, I think while we're all thinking about it. So Bartlett says that to qualify, to assert an existing district, once a district's drawn, if you want to assert a Section 2 claim, the district itself has to be more than 50% minority, or the area from which the district was drawn has to constitute a 50% minority district.
And that's the next point. It comes under compactness. And the compactness requirement, as you'll see, applies to the geographic area the minority group is in.
Gotcha. And then, Madam Chair, another question?
Yes.
Hold on, Delegate Simon, people are having difficulty hearing you.
Okay, I'll be speaking right into it. Is that
Okay,
better?
Thank you, yes.
Okay. All right, so the second question, so you said that coalition districts are permitted, and influence districts, although they aren't required by Section 2, are allowed. Reading a little bit ahead in the memo, I think there may be some disagreement amongst Republican and Democratic councils, but your position is that even though we don't have to establish influence districts or treat coalitions as folks that have an opportunity to create an opportunity district, we could legally do that if we wanted to consider those folks a community of interest, or does something else have to come into play before we consider a coalition of minorities a community of interest?
You do have the authority legal authority to create influence districts or based on communities of interest, say, as you just provided an example, or a coalition district or a crossover district. Those are still permitted, and even my Republican council friends agree with that it's permitted. They say, however, that it's not required under Section 2, and I don't think that there's a blanket prohibition against all coalition districts, which I'll explain in a few minutes. I do think that there is still room for those under the Voting Rights Act in Section 2.
Thank you, Madam Chair. That helps me make sure I was following along. Sounds like I am.
Thank
So
you.
thank you.
And Mr. Hebert, can you just quickly go over the 4 jingles, I guess, criteria tests? I think the first one was a minority group must constitute 50% or more of a district. Is that right?
Is the minority group sufficiently large and geographically compact to constitute a majority in a district?
Okay.
That's factor 1.
Okay.
Factor 2 is the minority group politically cohesive?
Okay.
Factor 3 is the flip side. Does the white majority vote, quote, sufficiently as a block, BLOC, to enable it to usually defeat the minority preferred candidate? And then the fourth factor is one that was added in the DeGrande case called Totality of Circumstances. Courts, when they're faced with a Section 2 case, federal judges not only have to make findings of fact as to factors 1, 2, and 3, they actually have to make a separate finding that notwithstanding those 3 factors, under the totality of circumstances, which they have to then describe what factors those are, circumstances those are, that under the totality of circumstances, there is vote dilution. So that's the fourth
Okay.
factor.
Right. Thank you for that specificity. Okay. Keep going.
Okay, so in addition to asking whether the minority group is sufficiently large, which is that first prong of jingles, it also asks whether it's sufficiently geographically compact. And we have a paragraph there that both sides have agreed on, and Lulac v. Perry out of Texas, the case that went up to the Supreme Court, it clarified that that compactness requirement we're talking about applies not only to plaintiffs who are bringing Section 2 cases, but actually to states that are drawing districts. So as part of the redistricting plan, congressional plan in Texas, Texas had dismantled a geographically compact majority-minority Latino district, and they replaced it with a district that stretched, and if you're familiar with Texas, you'll know what I'm talking about here. It stretched 300 miles that combined 2 geographically separate groups of Latinos who not only were separated by distance, but who had divergent needs and interests. That district stretched from Austin, going south, past Laredo, past San Antonio, all the way down to the Mexican border near Laredo. And the Supreme Court said that just as a minority group must demonstrate that they are sufficiently large and geographically compact to be a majority in a district, a state can't dismantle a compact majority-minority district and remedy that violation by replacing it with a district that has two, quote, far-flung segments of a racial group with disparate interests. The district actually looked like a barbell turned on its head, with minority population in the Austin area, almost nobody in between following an interstate, and Latinos down at the Laredo border. The court rejected that. Now, for some time, there's still been some competing definitions of compactness in the cases that expert witnesses have come up with. Some experts look at compactness and they say it's a matter of geometry, whether you use a mathematical formula or the so-called ocular test, the eyeball test. They analyze a district's compactness in terms of its shape on a map. In particular, they focus on the regularity or the jaggedness of the district's edge and the degree to which the territory around it is dispersed around the center. And there are various mathematical statistical tests for measuring compactness. I think the last time I checked, they were in the 30-something tests. The smoother a district's border, and then we go on to page 7. And again, this is all things that both sides have agreed on. The shape resembles a square or a circle rather than a spider or a string bean, the more likely it's going to be deemed compact under this particular view that experts take. Other experts take a more functional approach that look at the distribution of the district's population in relation to such other features as mountain ranges, rivers, bays, Shenandoah Valley in this state, lines of communication that exist, transportation, recognized neighborhoods, and so on. And it looks at whether or not, as a function of the district, whether candidates or legislators elected in those districts can actually explain to their constituents the boundaries of their districts in a simple kind of common sense term based on recognizable geographic features, like I live on the north side of Main Street, or I live west of 95 or 295. People know that usually. So an example might be a district that contains an easily recognized part of a county with discernible boundaries, or a border, like a river. In Richmond, for example, the city of Richmond has 2 councilmanic districts that are south of the river, I believe, in their entirety. People know that they're below the river, live on that side of the river. An example, the question is not, therefore, whether the district is aesthetically pleasing when you look at it, when looked at, say, vertically on a map, but whether it makes sense to the person on the street who kind of looks at it horizontally. So compactness is measured under Section 2 differently in Section 2 cases than they have in racial gerrymandering cases brought under the 14th Amendment. In the racial gerrymandering cases, the court has often referred to the geometric shape and objective measures of jaggedness and dispersion, and at other times focused on whether the use of race supported other more functional concerns, such as respect for city-county lines and for recognizable communities of interest. But LULAC, that LULAC v. Perry case I mentioned, held that unlike racial gerrymandering, which looks at the shape of districts, under Section 2, the first jingle condition refers to the compactness of the minority population, not to the compactness of the district that's being challenged. And that's an important distinction. The Supreme Court in LULAC noted that no precise rule had emerged yet for governing Section 2 compactness, unlike in the racial gerrymandering cases, but they emphasized that there was a need to recognize several of the non-geographic figures shared political and cultural interests. For example, I mentioned that the Latinos in Austin had a totally different cultural interest than the Latinos down near Laredo. Some spoke no English, others spoke English and Spanish equally well. So the compactness standard under that first prong of jingles, Delegate Simon asked me about, includes both geographic factors, traditional non-geographic components like historical boundaries, and man-made elements and an awareness of communities of interest even within minority groups. Now, we take a little bit of a different view in some of our comments, and it's interesting because I read my co-counsel over there, Republican side's comments, and I actually agreed with most of what you wrote. We have some disagreements, and I'd like to at least explain, and I'll stop after the first one so that you can hear some additional words from either Mr. Bartolucci or Mr. Tyson.
And Mr. Hebert, Greta Harris speaking, I'm just monitoring the time, and I know that this is really complex. It has a lot of nuances, but if we can continue to move ahead with the explanations so that we can get to some of the other criteria too.
Okay.
But I know that the Voting Rights Act is probably the most complex of the four that we're going to be talking about.
I hope you're correct, and I believe you are.
Okay, thank you.
So I have a comment there on the middle of page 7, additional legal background from Democratic counsel, and I say that to ensure that the Commission's plan doesn't violate Section 2, what I think you should do is identify, and the map drawer should identify, those existing Senate and House districts in which the minority group constitutes an effective voting majority. I don't think anybody really disputes that. Such districts should be analyzed to ensure that, A, under Dr. Palmer's test, racially polarized voting exists in that district, and that the minority group is sufficiently large and geographically compact enough to be a majority in a district. I don't think anybody disputes that either, because those are the three jingles factors. As noted above, the first prong of jingles is met if the minority group constitutes an effective voting majority in that reasonably drawn alternative district. Now, I will then just say that the Republican counsel, and obviously he can speak for himself, but I just want to highlight that I agree that his first sentence, compliance with Section 2 matters because if the Commission separates citizens into different voting districts on the basis of race without sufficient justification, its maps would violate the Equal Protection Clause of the 14th Amendment. I completely agree with that. And in fact, that's a language out of the Bethune-Hill case in the U.S. Supreme Court that found that Virginia's map was a racial gerrymander in violation of the Constitution because it did separate voters that way. Then I agree with the next sentence, which says the Supreme Court has explained that the harms that flow from racial sorting include being personally subject to a racial classification, as well as being represented by a legislator who believes that his primary obligation is to represent only members of that racial group. That is exactly what the Supreme Court said in Bethune-Hill. Now, the next sentence is one that I would only add something to. While map drawers are always aware of racial information, map drawers cannot subordinate traditional redistricting criteria below racial considerations, because then race predominates. And I would add that, yes, they can if they have a compelling state interest for doing so, which is Section 2 of the Voting Rights Act. So drawing districts in the Republican counsel continues, required by Section 2, is generally considered to be a sufficient reason to allow race to predominate and take that more significant role in the decision-making process about where to place district boundaries. But that governmental interest only applies when the districts are actually required by Section 2. That is, and that's the area where we essentially agree. You have to, if you're going to allow race to predominate, in drawing a district, you have to have a compelling state interest that's narrowly tailored for doing so. That's under the 14th Amendment. And Section 2 has been assumed to be a compelling state interest. The Supreme Court has always assumed it without ever deciding it. So I'll stop there, Madam Chair, so that we can...
Thank you. Chris, are
Well,
you...
Actually, Jerry, do you want to finish what you have to say, and then we'll turn it over to Brian wouldn't
Okay.
it be better to proceed that way?
Yes, and I'll be fast, Madam Chair, because I know you have other factors to deal with.
Thank you very much.
We have on page 8 from all counsel that legal principles show that this whole process is complex, it's fact-intensive, and the following sources of factual data will guide the commission through the process. The 2020 census, the RPV analysis that Dr. Palmer did, looking at past election results and applying them to newly created districts to see if the new districts provide minority voters with an opportunity to elect their preferred candidate. What you can actually do, that's called reconstituted election results. You can take past election results and you can put them in a new district and see how candidates fared. And the Legislative Services database actually has a lot of those statewide races. And we could take, just to pick an example, Justin Fairfax's race, who was an African-American candidate who prevailed statewide, and you could look at how he did in a particular hypothetical newly drawn district and see, were minority voters politically cohesive? Yes. Did they elect the candidate of their choice in that district? Yes, if he got a majority of the vote or a sizable plurality. So that's what I mean by those things. And then we gave you some examples, followed by comments from each group. And I'll quickly just give you one example because I think it applies to all the examples that appear at page 8 through 9, and actually on to 10. Assume a current Senate or House district is majority black in voting age population. If such a district has been identified as one where there is racially polarized voting, then the 3 jingles prongs have been met and the district must be retained in any new plan in a manner that black voters will continue to have an effective voting majority. And then I say, note that this does not necessarily require that the commission maintain the district as a majority black VAP district. Rather, the district as redrawn by the commission must continue to simply provide black voters with an effective voting majority. Now, because the hypothetical notes that it is possible that you have a majority black district in the first place and you have racially polarized voting, both prongs, you have met Section 2's preconditions under Jingles, assuming the court believes the totality supports it, and that therefore the district can be redrawn in a manner that provides, say, black voters, instead of being 51 or 52%, are 48, and maybe Latinos or Asian Americans who also vote for the same candidates that black voters do, that would continue to be an effective voter majority for black voters. Now, we disagree about this. All 3 Jingles prongs must be met, say the Republican Council, I agree, for determining the maintenance of districts and for creating new districts. That first sentence, Mr. Bartolucci, I agree with that. However, where we disagree is where you've inserted the word single in the next sentence. If a single racial group cannot constitute the majority in a new district, then the district is not required by Section 2 and cannot be drawn on the basis of race. Now, where we differ is because I think that if black voters and Latino voters in an area vote the same way and are politically cohesive, and the district with their 2 groups are over 50%, I think that meets the Jingles prong, and that it's not precluded by Bartlett's 50% rule. Remember, in Bartlett, the district was about 45% black, but it was impossible to create a majority black district. And so the Supreme Court said, no, if you're going to meet the requirements of Section 2, you have to have a district over 50%, and you're not able to do that. Well, here, in this hypothetical, I'm actually saying, yes, you could create a majority black district, but you don't necessarily need that if you can supply other minority voters who are also protected under the Voting Rights Act and vote cohesively with them to elect the candidates of their choice. So you'll see in the other examples that go along that we sometimes have a disagreement about the use of the word single racial category. And I will stop here only because, A, of time, but B, to note that one of the things that the commission needs to avoid is to put minorities in a district at a level greater than they statistically need to be to elect their candidates of choice, because to do so packs those voters needlessly, it wastes their votes, and provides them with less influence and opportunity to elect in other districts around them. Thank you, Madam Chair.
Thank you, Mr. Hebert. Mr. Bartolucci, or is
Mr.
Brian?
Tyson is online.
Okay,
He'll be
Tyson,
addressing
okay.
the Voting Rights Act for us.
All right, thank you. Mr. Tyson?
Good afternoon, Madam Co-Chair. Good afternoon, Commissioners. I apologize I can't be with you there in person today. I was planning to, but ended up with a hearing this morning, so we'll do this virtually. I think Jerry has very well summarized kind of where the differences are. And I think that the key piece you're going to find is this category of whether we look at race as individual racial categories, which is what we would assert is the reading that Bartlett had given us from the U.S. Supreme Court, or whether we look at racial groups in combination with each other. So as Mr. Hebert has just kind of explained, from their perspective, if you can draw a district that is majority non-white, but will elect a candidate of choice of the minority community and can show some cohesion between those groups, they believe that is required by Section 2. And I think the difference for us is we don't believe that's required, but we believe the commission is able to do that. So in terms of why this matters for you as commissioners, if you use race as a means of drawing a district, if you're creating a district and you say, aha, we want to make this a 40% Asian district or take some specific racial target in mind, you can't do that in a manner that is constitutional unless you have a compelling interest, which would be compliance with the Voting Rights Act. So as Mr. Hebert's explained, you have Section 2 that has generally been presumed to cover that for a jurisdiction. The key is the district has to actually be required by Section 2. You as the commission are free to draw, and I think we've seen over the past few weeks, both Mr. Morgan and Mr. Strasma, districts that end up being heavily influenced in terms of minority populations, just based on the geography, people living area of decision making where it's making the decision about where to place a boundary, and instead allowing you to use race to create that Section 2 district. So ultimately, when you have these three jingles prongs, that's, as Mr. Hebert outlined, that's important. If there's not racially polarized voting happening in a particular part of the state, as Dr. Palmer looked at, then there's no basis for the drawing of a Section 2 required district in that area. And you can't subjugate or you can't promote race basically in terms of categories above other redistricting criteria that you're using. If there is racially polarized voting in an area, now you have to look and see, can a single racial group constitute a majority in a district? And if they can, and there's racially polarized voting, and we have the other things that go along with this, then you use race to create that majority of a single race district. Now, it doesn't have to be 55, 60, 70%. That's not what we're talking about here. But the district itself would have to be over 50% in order to be required by Section 2. If a district under 50% is able to elect the candidate of choice of the minority community, often that may be an indicator that there's not legally significant racially polarized voting happening there. And I think it's significant. We both agree in terms of what are referred to as crossover districts, that those districts are where white voters are supporting the candidate of black voters generally are not required because that's not indicative of racial polarization in voting. Where we disagree is the situation of both influenced and coalition districts. Influenced districts would be districts where the minority population has a high degree of influence, but still doesn't control the overall or could control the overall outcome. And coalition districts where you have multiple racial groups kind of aggregating together to get a majority non-white group. So again, the key for y'all is if you look and a district is required by Section 2, meaning that there's racial polarization in that part of the state, you can create a district that is more than 50% of a single racial category, then you must create that district and you're allowed to use race. If you create a district drawn on the basis of race or with race as a primary consideration in an area where that's not required by Section 2, you've now drawn a map that is walking into potential constitutional violations because you're creating the type of racial sorting that the Supreme Court has warned about. So I think that kind of summarizes the issues and decision point for y'all. I'll pause there, and I'm sure there'll be plenty of questions from everybody.
Okay, that was a lot to take in over our first hour. And Senator McDougal.
I think that last point is what I would like to hear from Mr. Hebert, his position on.
Speaking to the mic.
That last point is what I'd like to hear from Mr. Hebert.
So,
Saying, go ahead.
no, go ahead.
No.
So what I heard Brian say was that if a district, a 50% minority district can be drawn, you then can draw it under Section 2 of the Voting Rights Act, and you can rely on race in doing so because you meet the Jingles preconditions. And I agree with that. Where we disagree, however, is that just because you can draw such a district that's 50% or greater and you meet the Jingles prong, are you then stuck with that quota? Or can you look at the votes of other minorities in the district and see if together you can also provide blacks with an effective voting majority, even though they may be a little less than 50? And it seems to me that Bartlett doesn't address that issue because it wasn't a district, it only involved black voters. There was no issue about whether Latinos could vote with them. As I said earlier, it was only that you could not create a majority black district there. And so therefore, since you couldn't get over the first prong, Section 2 didn't require that district and the state couldn't rely on it. I will, however, though, Senator McDougal, give you this language from Bartlett that I think helps get us to where I think you should go. In the Supreme Court, it said, quote, if there were a showing that a state intentionally drew lines in order to destroy otherwise effective crossover districts, that would raise serious questions under both the 14th and 15th Amendments. Now, what I take away from that is that if you can make a coalition district and you choose not to, you may end up on the defendant's side of a Section 2 case if that crossover vote is not from whites, but from other minorities. Does that help?
Madam
Okay,
Chairman.
yes.
Okay.
Senator
Madam Chair?
McDougal. Yes.
May I? Were you?
Yeah, I was going-
Senator McDougal, and then I'll come to you.
Okay.
I should have been clear in my question because you didn't answer it.
Okay,
So
I'm sorry.
What I heard Mr. Tyson say was that his interpretation is if you draw a district on race that is not the Jingles test, that could subject you to litigation in violation of the 14th Amendment. Maybe what I heard you just say is you think it's okay to draw a district on race, and that does not put you in violation. So I want to know what each of y'all think about that.
Okay. So I apologize, I didn't realize that's what you were asking, but I will say that what the Supreme Court has said is if you predominantly rely on race, and in doing so you support traditional redistricting principles and don't have a compelling reason for doing so, like compliance with Section 2, that violates the Constitution. That's what Brian said, and I agree with that. I don't say that if you can't create a majority district, or if you don't have racially polarized voting in a district, that you can still take race as a predominant factor and draw that district. I think you then are in the strict scrutiny area of constitutional law, which says that if you predominantly rely on race, you have to have a compelling reason for doing so that has to be narrowly tailored. And I don't think that you would meet those standards if you relied on race without those other factors being present.
Brian, do you have a response to Senator McDougal's question?
Yes, Madam Chair. So in terms of, I think Jerry and I agree on the large point here, which is if you're using race and you're not required to do so by Section 2, then you are running yourself into a constitutional violation. I think if I can kind of categorize the difference, that from our perspective, if you're using race to, let's say, create a 40% Latino, 20% Black district, and so you're using race to kind of build that coalition district, but you don't have a majority of a single race in the district, our position is that it equally would run afoul of the constitutional provisions because there's not the majority of a single race in the district as required by Section 2. And Jerry can correct me if I'm wrong on this, but I believe from his perspective, there would be a basis in Section 2 to use race to create such a district if the commission saw fit they wanted to. We believe the commission could do that if you didn't use race as the primary motive for it, because it's not required by Section 2, which is why you can't use race as the primary vehicle for creating such a district.
Okay, so a lot of nuances. Okay, Senator Locke is on the Zoom. I'm going to get to her, then Mackenzie, and then Richard Harrell. Senator Locke?
Thank you, Madam Chair. I had two questions for Mr. Tyson, if you don't mind. One has to do with the document that we got. It's at the bottom of page 7. I just needed some clarification on the additional legal background from Republican counsel. It says that compliance with Section 2 matters because if the commission, quote, separates citizens into different voting districts on the basis of race without sufficient justification, it maps violate the Equal Protection Clause. I just need clarification as to what that means. And I'll go ahead and ask the second question, then I'll mute myself because I have students coming in and out of my office. And the second one has to, on page 8, has to do with the Shelby versus Holder case, which gutted Section 4 of the Voting Rights Act. And it says that because of that, it did away with the coverage formula. And as a consequence, Section 5 prohibited retrogression, which decreased the number of majority-minority district and therefore no longer applies to Virginia. Are you now saying that retrogression is now okay?
Okay, thank you, Senator. So yeah, let me go through those. So on page 7 first, so compliance with Section 2, so that's quoting Bethune-Hill from the U.S. Supreme Court. And the key question there is if you are kind of promoting race as the reason why you're putting a line somewhere, that's the issue where the Supreme Court says in that situation, you're running afoul of the Equal Protection Clause unless you have a compelling government interest, basically a really, really good reason for doing what you're doing. And that really good reason could be a variety of things. It could be following jurisdictional boundaries. It could be trying to represent a community of interest. The question is if it includes a compliance with Section 2 of the Voting Rights Act, that has always been assumed to be a compelling government interest. So you're allowed to break jurisdictional boundaries. You're allowed to kind of disregard some of the other traditional principles of redistricting if you are complying with Section 2, if you're drawing a district that Section 2 requires. So that's what that paragraph is referring to. The Shelby County question on page 8, important distinction in the Voting Rights Act between what the law requires for Section 2, which is prohibiting vote dilution, and what the law requires in Section 5, which is prohibiting what's called retrogression. So retrogression in a very general sense, under the pre-clearance standard that Shelby County did away with, essentially looked at the total number of majority-minority districts in a jurisdiction on the new census data and said it's like a one-way ratchet. You can't go backwards. You've got to keep going forwards in terms of what happens there. So what you do is you look at the total number of districts on a jurisdiction-wide basis and pre-clearance and determine did you go backwards or not. That's a different standard than are you diluting minority voting strength in individual areas of the state where the jingles preconditions apply. So the reference to Shelby County here is just so that the commission will understand that in terms of maintaining existing ability to elect districts, those have to be evaluated under jingles. They aren't evaluated under kind of a you can't go backwards standard because that is not in force anymore, but you do have to look district by district at the vote dilution questions of Section 2, which many times is going to lead to the same result as you would have had under Section 5 and pre-clearance. So I hope that helps clear that up a little bit.
Okay. Ms. Babachenko.
This goes to crossover districts and to Mr. Hebert. What, the words you used were intentionally drawing a line, I think, to break up a crossover district. Is that what you said was the problem? And my issue, or my question, is we started from blank maps. And so how does that figure into all of this, if anything? I think I understand if we had the current maps and we were moving lines, and that could be an intentional movement, knowing that what we were doing. But since we're starting from blank maps, they're not really supposed to be looking at what was a crossover district or not. So how are we getting to intention, or do we get there, or how does that work? How do we get to, I'm intentionally now potentially drawing a line through a crossover district to dismantle it when we're starting from blank maps?
That's a good question, because you are starting from blank maps, and the map drawers have been instructed to do that. And let's assume that in drawing that district, they come up with a district that is 40% Black and 20% Latino, say, and they look at Dr. Palmer's report and see that he has determined that minorities vote politically cohesive in that district, and that whites vote as a block against them. But since they are together, it's not really a racial crossover district. It's what I would call a minority coalition district. Both sides agree that that district could be drawn. Where I think we disagree is that I think that if minority voters are politically cohesive in that district and they constitute a majority, Latinos and blacks, that district should be drawn under Section 2 of the Voting Rights Act. I wouldn't necessarily call it a crossover voting because it's not a crossover district, because it's not a district in which minorities need white voters to cross over and vote, unlike the jingles prong. 3, that they vote with the minority candidates. You don't need that in that kind of a district. Does that help?
I think it does, but I mean, it would require somebody to see the district first, know that it could be drawn, outline it, and everybody agrees that it could be drawn, and then say, I'm going to take a line and draw through it anyway. Is that the intentional, is that what we're thinking that means?
Well, another option, Ms. Babachenko, is that a group out there, they don't have to draw districts on a clean slate. They could look at the current districts and say, hey, this district is performing as a coalition district. And your line, even though you drew it on a blank map, you cut right through that and you divided that. Where they previously had a coalition district, or even in my definition, a coalition district or a crossover district, you intentionally cut that in half under this map that you're about to adopt. If you did so, an argument could be made that you intentionally, under the Bartlett case, raised serious 14th and 15th Amendment concerns.
Okay, but I mean, that helps, and I guess they would tell you that you were doing it first, and then if you maintained the line, is that?
So I think
I'll just,
as we see maps beginning next week, we're still going to have to take into account Dr. Palmer's work, and there may be some reference back to existing maps as well, too, because Dr. Palmer's work is based on the existing maps. So I think we'll be using lots of different information to help inform our final decisions that we'll make as a commission here. So, okay, Mr. Harrell, and then Sean Kumar.
Thank you. I guess I'll address this to Mr. Tyson, and Mr. Hebert can chime in after Mr. Tyson. my roughly general concern is around the same area as, in a way, I think, as Senator Locke and Ms. Babichenko. I'm trying to see what our obligation is in this completely newly redrawn districts. Now, as best I can understand it, we are in this process disregarding the race issue, which is very important, but disregarding up to this point, we're trying to use traditional principles and draw districts that make sense in terms of compactness especially, and using county lines and other political boundaries also, and a number of other factors. In the racially polarized areas, as already defined for us, I also understand, let me preface one more thing. I understand that there's language in this document somewhere that I read earlier, a little while ago, that said the Supreme Court puts us under no obligation to maximize the majority-minority districts. That's plainly been stated. I did understand, and he'll respond, I'm sure, after Mr. Tyson, Mr. Hebert's general remarks to indicate that if we took what he said in terms of creating majority-minority districts whenever we could, that by extension, that argument takes me to maximizing the majority-minority districts. And I guess I have a couple of specific questions. One, and I asked Mr. Tyson first to say, as we look at this map, and we've got X number of majority-minority districts, do we have to, by any obligation from the Supreme Court, create the same number, more, let them fall where they may? Or are we in the obligation to maximize those that we already have? And secondly, if we do create new majority-minority districts with boundaries that under traditional principles appear to be more reasonable, such as county lines, et cetera, if we come up with 53% black, where in the previous district, somewhat right around there, it was 52, is that a packing issue? And that's it. Thank you.
Thank you, Commissioner. So I'll begin with that. I think your maximization question is an important one that I'll give just a little bit of historical context there. So in the 1990 cycle of redistricting, there were several states that took the position that the Voting Rights Act required the creation of the maximum number of majority-minority districts in a jurisdiction. And so essentially what would happen is people would draw them out, they would submit it, then some other group would come in and say, I could kind of tweak the lines this way and create one more majority-minority district over here, and now therefore you're in violation of the Voting Rights Act. And it was essentially using race as the only way of determining that. And the Supreme Court said, no, you've got that wrong. That's not what the Voting Rights Act requires. So in terms of kind of what are the limitations on that, really, I think the geographic compactness of the minority community is key, as the Supreme Court said in LULAC. It's not a matter of going and just finding people and connecting different communities into districts. It's a matter of, is there truly a geographically compact minority community in the area? And so in terms of, if you draw the districts as they are now, I think that what happens is there will be a question of, do we then need to depart from any of the traditional redistricting principles that we're using in order to comply with the Voting Rights Act? So if we drew, just squares across the state and we ended up with a certain number of majority-minority districts, is that a sufficient compliance with Section 2, or in areas where there is racially polarized voting, could we draw additional districts that need to be there because there's a geographically compact minority community? So that's, I think, for number one, there's not a magic number of districts that you have to meet. We'll have to look at each area. And then in terms of what would happen if you drew using kind of non-racial criteria and then ended up with a 53% district, let's say, when it was 52, Then the question becomes, what is around that district? And so if you have a district that's next door that is 49%, there's a high degree of racially polarized voting in that area. And moving some of the voters from the 53% district to the 49% district would lift that district above that Jingles 1 threshold. And that was then going to be an effective voting majority. Then you would have to do that adjustment. If all the districts around that 53% district were not districts that would otherwise be ability to elect or otherwise couldn't constitute a voting majority of a single race, then you wouldn't need to then allocate those voters differently. You could stay with the traditional principles you use because there's no other Section 2 required district that's touching that one. And I know Jerry may have a little bit different perspective on that second example, but that's where we would recommend you go on those two questions.
Mr. Hebert, do you have a response?
Yes. First of all, Mr. Harrell, I'd never talked about maximizing the number of majority-minority districts. What I did say was that I think that you have the opportunity where you have the three Jingles prongs present. I think you have an obligation under the law to draw those districts so that minority voters have effective control over them. That may result in more minority opportunity districts than you have, majority-minority districts than you have now. But if the Jingles prongs are satisfied, then in my view, you need to draw them. That doesn't mean you need to draw them at any cost or engage in the racial gerrymandering that existed in the 1990s that Mr. Tyson just identified, because I don't think there was the analysis under Section 2 that justified drawing the districts the way they got drawn in that period. I also, by the way, agree with Mr. Tyson that if you have a district that was 52% and you have now increased it, 1% can be a sizable number of people, and you have a neighboring district in which minority voters are not able to have an effective voting majority, but they're right on the cusp of having it, then I believe that failure to do so could constitute a violation of Section 2 of the Voting Rights Act, because it's not so much that you're packing one district, it's that you've cracked the minority population in such a way that they would have an opportunity in a racially polarized majority-minority district to elect their preferred candidate.
Okay. All right. So we're going to do Sean Kumar and then Delegate Adams. I'm looking around to see if there are other questions. Senator Stanley and James Abrinio. Okay. But then what we're going to try to do after those four comments is I'm asking both legal counsel to state to the commission specific we've had a great education today. What guidance do we need to give to Matt Doors? That's what we're thirsting for here, but we'll continue to get clarity on things. So Mr. Kumar, Delegate Adams, Senator Stanley, and then James Abrinio. Thank you.
Thank you, Madam Chair. This is Sean Kumar. So my question to council, and I get it, the answer is probably it depends. How much of an impact do we think, how many areas, how many districts do we think this could impact, right? As we talk about this, and as we think about how important this criteria is and how much time we even allot this issue, I imagine it depends on current districts, new districts. We don't know what the final new map is going to look like, but the magnitude, do we think this could impact maybe 10% of our decisions in districts or greater than that? Or that's my question.
So I'll take a first stab at that. And I would say that it does depend. But what it depends mostly on is the growth of the minority population in the state as reported in the census and where that growth is in relation to the current districts as well as the opportunity to create new ones to effectuate that growth and give them the voting power they deserve.
Okay, Mr. Tyson, do you have a response?
Yes, Madam Co-Chair. So I think Jerry is exactly right there. There is a lot of it depends on that. I think where this is going to make a difference is areas where there is racially polarized voting under Dr. Palmer's report. So, for example, in Northern Virginia, where you had very little racially polarized voting, I don't think this Section 2 really affects it at all because this isn't a consideration there. I think this is going to be those areas with racially polarized voting. you have to go and look, are there districts that we could draw that could be ability to elect and above 50%? And if not, then that won't affect it as much. The key is going to be if adhering to your traditional redistricting criteria creates, for example, two 30% Black districts. And then, but if you could unite those districts together, they would be 60% Black, and that was the number that was required. That's just all hypothetical. It's not saying that would be, it's far too high based on Dr. Palmer's analysis. But the idea is, are you splitting a community that could be a single race that could be together for purposes of drawing a map? So I think that's the thing to look for. Areas with a degree of racially polarized voting, that's what you're looking for in terms of where this will affect your decision making.
I get it, and this is Sean Kumar again. So I get it, and even one violation, if it's a violation, could trigger a challenge that would mean redrawing. But when it comes to the amount of districts impacted, like an estimate, would you guess, and you may not know yet, but even knowing 30% versus 70% would help a lot into the impact of this?
I mean, for me, I know in the memo we list out there's one Senate district that's currently over majority Black on voting age population, 9 districts that are over 50% for delegate districts that are over 50%. And so I think those are the ones you're primarily looking at, those Senate and House districts that are currently over majority on voting age population. So that's currently 9 delegate districts and 1 Senate district.
Thank you.
Okay, Delegate Adams.
Thank you, Madam Chair. I just had a question, I guess, for both council with regard to a clarification of terms. Under Section 2, there's the phrase is protected minority group. And I'm just curious, are there any other distinctions besides the tests that you've laid out with Jingles and others is there any distinction between a minority group and a protected minority group under Section 2? And then Mr. Hebert had used the phrase coalition districts. And, with respect, I think, to minority groups, is that something that's reflected in the case law? Those would be my 2 questions.
Okay. I'll answer the second one first. The answer is yes, that coalition districts have been referenced in the case law. They've been approved by the 5th Circuit, the 9th Circuit, the 11th Circuit. The only circuit that has not allowed coalition districts is the 6th. I don't believe the 4th has ever addressed the issue, so it's outstanding. Although there is a case right now out of Virginia Beach that involves coalition voting among Blacks, Latinos, and Asian Americans. So that's as to that. I don't believe there's any difference with respect to protections that are afforded Blacks, Latinos, Asian Americans, American Indians, Pacific Islanders, all groups that are protected under Section 2 when it comes to redistricting. I think there are cases in South Dakota that talk about providing Native American voters with opportunities to elect candidates of their choice in redistricting plans. There have been, when I represented New York City and we drew districts there, we had to look at Asian populations, different ones, and Latino populations, and African American populations, and treat them all the same way with respect to protections afforded under Section 2. Mr. Adams.
Mr. Tyson?
Yeah, Madam Co-Chair, I'll just briefly add, I agree with Jerry on that. I think the key point is, are you the minority? There was a case in the early 2000s in Mississippi where there was a Black majority city that was preventing the white minority from having effective electoral opportunities, and the Voting Rights Act was extended to the minority white voters in that jurisdiction. So generally speaking, minority voters, it's going to apply if you're the minority. And on coalition districts, I think the key question is, are they allowed or are they required by Section 2? And I think that's where we still kind of have a lack of direction, especially from the U.S. Supreme Court, on whether or not a coalition district would be required by Section 2. And our reading of Bartlett is that that's not where the Supreme Court would come down on that. But I think that's the key question. You, of course, can draw those districts, but are you required to draw them under Section 2? And we would say the answer to that is no, because there's more. It's not just a single race in the majority.
Okay, Senator Stanley, thank you.
Thank you, Madam Chair. This is Bill Stanley. This may sound like a silly question, but I'm listening to a bunch of these, we're talking about voter data, the factors of, past voters, their history and their performances. In terms of determining these areas which we've used phrases like effective voting majority, cohesive in those ways, and I'm asking both counsel. It would seem to me, and I'm asking them if they agree or disagree, and if they agree or disagree, explain why. I mean, aren't the results of primary elections just as significant as those of general elections in determining the jingles test? It just seems to me that it's just as important, but perhaps what I've been hearing is we're only talking about general elections as making those determinative factors when it comes to jingles. Thank you, Madam Chair.
I'll just go ahead and say that primary elections can also be relevant under Section 2 for measuring performance of minority voters. I think that general elections are a better gauge overall because they're not a subset of the electorate. They're the entire electorate that's voting. And so you can also look, though, at primary elections to see, given the minority percent in the district, as well as whether or not voters are cohesive in that district, minorities, whether or not they have the ability to control the primary. And if the district is overwhelmingly Democrat, then they're going to elect the candidates of their choice in the general. So they can be relevant. They're not always relevant, but they can be relevant. And they certainly are not relevant in nonpartisan races.
And I would agree with that in terms of what we use. And Senator, you've kind of hit on one of the issues that I think we face as a level of uncertainty with the Voting Rights Act is over time, you've seen more and more of a kind of partisan gloss on a lot of the analysis, where it used to be that the race of the candidate was the determining factor. Now it's often the party of the candidate. There's a lot of, again, uncertainty in the space. But I agree with Jerry in terms of your general elections are the ones that are generally going to have the most data points to help you determine racially polarized voting. That's what the case law is on it right now. That might change some more as time goes on, but generally speaking, you're going to look at general elections and only primaries if it's a situation where there would be an opportunity for the minority community to elect a candidate of choice to make it through the primary to get to the general in a particular district, which isn't really going to be as applicable here.
Okay. Are you good, Senator Stanley? Okay. All right, Mr. Abrinio.
Thank you for that presentation, and I feel like I'm back in law school. Now, my question really centers on the prong one of the jingles test, and it sounds like there's a big divide, and I know you've said it over and over again about whether or not a claim, a Voting Rights Act claim, can be based upon using the minority as a group rather than looking at a single racial group. Why is there a distinction between Mr. Hebert and Mr. Tyson and the Republican Democrat? Is it are the Republicans looking at statutory language, or is it case law, or is it a philosophical difference? I'm trying to get a better understanding just from the law itself, so we can have that as a better analysis as to what we should be looking for.
And Commissioner, I can start on that if that works. So from our perspective, we're looking at the language of Bartlett and the logic of Bartlett in terms of what does the Voting Rights Act actually protect. And if you look at the history of how the Voting Rights Act was designed, the Section 2 in particular was primarily applied to situations where, let's say you had a county government that had 5 county commissioners, and they used at-large elections where everybody in the county voted for all 5 commissioners. In those kinds of situations, sometimes you would have the center of the county or a black group of voters in the district, in the county, who could constitute a majority if there was 5 districts. But because everybody was voting on it, the kind of 4 districts worth of white voters was drowning out the voices of the black voters in that situation. So Section 2 comes in and says, you must change to district-based voting so that the minority voices can be heard, and you create an effective ability to elect district. In a situation where the minority voters were not having their voices not heard because there's not racially polarized voting, there weren't enough people to constitute a district as by themselves, Section 2 wouldn't apply. So given that history, that application, and the language of Bartlett, that's why we believe it applies in terms of the intervention of the Voting Rights Act into state-based districting decisions. it really comes into play when you have that over 50% situation, because that's when you're actually drowning out the voices of minority voters, and that's what the Voting Rights Act protects. The other challenge you have is as our population has moved more toward a more polarized political environment, you don't want to get in a situation where the Voting Rights Act is being used to enforce a particular partisan outcome. I think you saw that used in the 1990s by a lot of Republicans who were trying to use the Voting Rights Act to create new Republican districts. And the fear is that if you extend the Voting Rights Act beyond a single racial group where their voices are being drowned out, you might begin using the Voting Rights Act on the other side to ensure democratic voting performance. So those are kind of the issues framed up there, but primarily for us, it's the history, the application, and then Bartlett in particular.
I would say in response that Bartlett does not address this question. It does create a 50% rule for people who are going in and challenging maps, and for the state's reliance on creating coalition districts that are less than 50% where you cannot draw those districts. In terms of the impact, however, in the two positions, which I really think is what your question really probes, I think that if you say that you have to have a single minority group over 50%, and only if it's a single minority group can you really provide the Section 2 come into play, I think what you're really doing is minimizing the opportunity for minority voters in the Commonwealth of Virginia to form effective voting majorities by voting with other minorities in that district to elect candidates of their choice, so-called coalition districts.
And if I could just have a follow-up. If I'm hearing that right, if the requirement is that we can only use one single racial group in order to make a voting rights claim, it seems to me like minorities such as Asians and Hispanics and less populous groups, would it not be essentially less protection? It's more difficult to make claims. I guess I just have a concern as we have an increase in minority populations, essentially singling out and saying you can only make a claim based on one individual racial group. I have a concern about that. I'm trying to get a better answer as to what the philosophies are there.
Well, I think you've basically recited the flip side of what I said, which is that I think that because other groups that are growing in their population over time, but haven't reached levels yet of either citizenship or participating in elections, or simply the population is either dispersed or not sufficiently concentrated in particular areas that they can now create their own districts in which they can elect candidates of their choice, that if you really want to not minimize their impact in playing a role in the political process, you ought to allow them to vote with like-minded voters that are protected under the Voting Rights Act and elect candidates to the legislature.
And Commissioner, I'll just briefly add on that from Jerry. I think the other thing to keep in mind is it is totally appropriate to draw districts where there's a significant influence of minority voters. The question is, can you subjugate other traditional redistricting principles to race to do so? I think it's also important context to remember that the primary decisions about redistricting are reserved to the states by the U.S. Constitution. And the Voting Rights Act, as a critically important piece of legislation as it is, and how amazingly successful it has been, is an intrusion on states getting to make those decisions because it governs how the states will make those calls. So in that sense, we want to make sure that we have as the Supreme Court has said, you got to have a congruent and proportional, they call it, remedy to what you're trying to address. And if the Voting Rights Act protects every group, no matter how small, and their voice in the political process, that's a very different response by Congress than it is when you have a group that is clearly enough to be a majority in a single district, which is what Jingles lays out, and then is not able to exercise that for a variety of other reasons. So we obviously want to have the voices of minority voters heard. There's no question about that. The key question for you as commissioners is, are you required to use race to get that done in an area? And that's where we would say it's only when it's 50%, over 50% of a single racial group.
Okay, Senator Simon, and then we have about an hour to go over the other criteria. And again, I'm going to be looking to our legal counsel to give us specific questions that we as a commission should be trying to vote on to give clarity to the map drawers. So, all right, Delegate Simon?
Thank you, Madam Chair. So I think just to sort of distill this to one example, and then maybe we can get some instruction would be great. So as I understand the difference between the two groups of attorneys, in an example, let's say you had a district that was...
Excuse me, Delegate Simon.
Yep.
Would everyone please mute their phones, please? Whether you're on virtually or here locally, please mute. Thank you.
So suppose you had a hypothetical district that was 30% African-American, 20% or 19% Hispanic, and 5% Asian, right? So it's majority, minority. You've got a plurality of whites, but they're a minority. If that district was 54% African-American, you couldn't split those African-Americans and put them in two white majority districts side by side. But what you're saying is you could take, because it's not 50% of any one group, you could take the 30% African Americans and put them in a district that's 70%, becomes 70% white by moving to the left. You can move the Hispanics to the right, and you could ignore the Asians, and you wouldn't be violating Section 2. So you could essentially crack them because they're not all the same race. And on the other hand, even if we wanted to, we couldn't keep them together. Let's say under our current criteria, we've set a benchmark of 2%. You know, if keeping them all together, because we wanted to, resulted in a district that deviated from our criteria of 2, and say took it to a 3% or 4% deviation, because they're not all the same minority group, we couldn't create a district that deviated that much if it was made up of 30% black, 20% or 19% Hispanic, 5% Asian. Am I understanding the two positions? So Jerry's position would be, yes, we could do that. We could deviate by more than 2%, but I think the Republicans' coalition is, because it's not all one race, you couldn't deviate. Am I kind of getting it right?
I think you are, Delegate Simon. So I think the key thing there is if it is an area with a high degree of racially polarized voting, which is also going to be another important factor, then you are not required by the Voting Rights Act to create that district. And so if you subjugated other traditional principles or your guidelines of redistricting to race in that context, that would not be required by Section 2 to be placing yourself into potentially violating Equal Protection Clause and the Constitution. And I think Jerry would take the opposite position, that that district is required by Section 2, and so that would not be an issue, but I'll let him address that.
I think that if minority voters are politically cohesive, you can combine them into a district that's over 50% minority that gives them an effective voting majority in that district. Section 2 is required to draw that district.
Okay, so we have opposing views. And so my question to both legal counsel, we had the census data, which is showing demographic changes in the state. We have Dr. Palmer's racially polarized analytics. And then we have potential new maps. And we have the history of our existing voting patterns. So all of that is data that will inform how we move forward. What is the question that the commission should ponder in the form of a vote to give clarity of direction to our two map drawers? That's what I'm trying to get to here. And Mr. Hebert, I'll turn it to you, and then Mr. Tyson, and then see if we have clarity around a potential motion to take this very complex issue and see if we can sort of synthesize it down.
Thank you, Madam Chair. I think that I'm going to try to come up with a proposal that perhaps Brian can agree upon that would be the basis for this commission instructing map drawers. And I have 4 factors that I would apply. Number 1, the guidance would be, don't let racial considerations predominate the creation of a district unless the Jingles 3 preconditions exist in that area. Number two, look and apply the racially polarized voting analysis
gonna
in the
need to slow
district.
down.
Okay, we'll go back and wait, say it one more time. This is, we're all trying to keep up with you here. Okay, so start with one again, please.
Yes, don't let racial considerations predominate the creation of a district unless you have the three jingles preconditions met in the area you're drawing that district. That's number one.
Okay,
Number two, apply Dr. Palmer's racially polarized voting analysis in districts to determine whether racially polarized voting exists in that area.
okay,
Number three, and this is the one that I think crosses the bridge for Mr. Tyson and myself. I'm trying to unite us here. Whether or not you are required to use just one race in drawing a district, or whether, as both sides agree, you're permitted to combine groups or create crossover districts. There's no prohibition in creating such districts by the commission, even if not required by Section 2.
okay.
And number four, utilize the census, 2020 census data and past election results in the DLS database to measure minority voting strength in the districts created to determine compliance with the Voting Rights Act.
Okay, all right. Did everybody get all four of those down?
Madam
Okay, all right,
Chairman,
okay, all right. We have
I'll just go to the last one.
Senator McDougal and then Delegate McQuinn.
Just go to the last one first. So the last one says use 2020 census data, which I think we all understand that. The second part, you're saying past results. DLAS doesn't have any, they don't keep results. That's the State Board of Election. They might have been imported from somebody else, but they didn't create them universally. The who? Okay, but y'all had to get that from somebody. You
Yes, we
didn't
got
make-
that from the State Board of Elections
Okay,
as
and
part
does
of the
that include
database.
primary and general election data?
We just had the general election data. There's no primaries included.
Why wouldn't we have both?
We just collected the general elections as a matter of course and weren't instructed to collect primary.
Well, I mean, I guess my question is, if you're looking at elections where you're predominantly electing Democrats, this last primary where there were multiple minority candidates on the ballot, and that was probably the most recent example, why would that not be included in that information?
What we've used in the past has always been general election results. So as a matter of preparing for redistricting, last year we collected general election results. If you all would like us to get primary election results, then we're certainly happy to do that.
Okay, Delegate McQuinn? Speaking, yep.
Thank you, Madam Chair. Just for clarification, the crossover group and the coalition group is basically the same group that we're speaking to, right?
I couldn't quite hear the end of that. They're basically the same.
Same, yes. Basically the same group. The crossover and the coalition group, because there will be minorities that come together or minorities that decide to, I guess, join forces to select the preferred candidate.
Delegate, in the law, in the case law,
Uh-huh.
crossover districts have oftentimes come up in looking at minority population that needs white crossover voting to vote with them, whereas coalition districts are districts in which minorities can combine their votes. And if I could, Madam Chair,
Ye-
go back to
yes.
the database question?
Yes.
I have obviously no objection, and I think it makes sense to get his primary election results, but I also think that the State Board of Elections should provide the district, Senate district, and delegate district election results too, rather than just the statewide races, if we can do that.
Okay. All right, Mr. Tyson, do you, I think Mr. Hebert gave us his 4 questions or strategies. Do you have suggestions as well?
Yes, Madam Co-Chair, thank you. And I appreciate Jerry working to find a way to bridge the gap. I'll try as well. I think what might make more sense is only not to do all 4 of these items, but to say to the map drawers, your instructions are to comply with the guidelines in terms of the communities of interest, the contiguity, as you draw your redistricting plans, would be number 1. Number 2, if you're drawing in an area of the state where there is a high degree of racially polarized voting, as indicated in Dr. Palmer's report, then look at the racial makeup of the districts you create. So for example, if you're creating a 55% district with a 48% district next door, look at that question at least to have that flagged for the commission. And then number 3 could be the number 3 that Jerry proposed. There's no prohibition on creating such districts in terms of whether it's one race or a combination of groups. And then I think the advantage of going with those 3 approaches is, number 1, it allows you to get maps that use only the traditional principles you have adopted as guidance, as the guiding light, basically. Then when you get those maps back from the map drawers, then there can be a consideration of, aha, here is an area with a high degree of racially polarized voting. So we have jingles 2 and 3. Let's now go look at what we can do to comply with jingles 1 if needed. Can we draw a majority-minority district in this particular part of the state or in this area? And I think then that will allow you to decide, yes, we now believe you should have race be a higher consideration than, for example, political subdivision boundaries or cultural affinities of groups that are together in drawing the redistricting plans. So that would be my recommendation. Again, trying to find a common area for us, apply the guidelines. If you're drawing in an area with a high degree of racial polarization, be conscious of the minority makeup of those districts, basically be able to bring that to you as the commission. And then number 3, whether you're required to use one race or combine, there's no prohibition if you're drawing while otherwise following the guidelines to create that kind of district.
Okay. All right. So, Mr. Hebert, do you have a response to Mr. Tyson's recommendation? And I'm seeing on Twitter that the governor just signed the Voting Rights Act of Virginia, like just now. And is that, does that impact this commission?
Madam Chairman.
It does not.
Madam Chairman.
Yes.
No, the governor had to sign everything, had to be in effect by July 1. That was ceremonial political event or ceremonial event. Nothing went into effect today.
Okay,
Everything was
all
in
right.
effect on July 1.
Okay, all right.
Unless it was through a special session that we've not yet been over, not yet finished.
Okay, all right. Sorry, just, just trying to share information. All right, we're going to hear from Mr. Hebert on your reaction to what Mr. Tyson recommended.
Well, first of all, I accept the friendly amendment of adding that they should comply with the redistricting criteria. So that's.
But can we assume that the map drawers are doing that anyhow?
I thought they were, but if we want to make it explicit.
No, but I mean, Mr. Tyson, on your first item, we voted on the criteria, and they should be following that. That includes, compactness and, adjacencies and all of that. Mr. Tyson?
I agree.
Oh.
I agree, Madam Co-Chair. I think the only thing I was trying to get to with that was just, since we were giving them specific direction about compliance with the Voting Rights Act, and that is kind of higher up in the chain of things they're supposed to be doing in those guidelines, that for this purpose, we didn't want to trump the rest of the guidelines by giving them basically new direction. That was my only intent there. I agree with you. They should be following the guidelines as it stands right now.
Okay, so now we're down to 2, which is using the racially polarized voting analysis and to be able to do, after they've drawn districts, that they would flag for the commission any issues in areas where there has been a high degree of racially polarized voting, and that the other piece that we would be voting on is that we would not be opposed to potentially seeing coalition districts in the final version of the maps. Okay, Jerry, sorry.
And I think that last one certainly is similar, if not identical, to what I was trying to say, which is that whether or not you believe that coalitional or crossover districts are required under Section 2, you don't have to address that issue, simply saying the map drawers are not prohibited from creating such districts.
Okay, all right, and I'm going to go back again. So now we're down to 2 directions, I think, that again, using Dr. Palmer's work. So once the map drawers draw their maps as they see fit using our criteria, then they go back and do another overlay using Dr. Palmer's work, and will give us, in their presentation, will begin to identify those areas with high degrees of racially polarized voting. And then the other piece, if we should vote on that, is that as a commission, we would not prohibit the creation of coalition districts.
And
Yes.
the only part of Brian's provision about using racially polarized voting is, I don't know that you necessarily need to put in the word high degree of racially polarized voting,
Okay.
because you can have racially polarized voting in varying degrees. What I would simply say is, as I said earlier, let's apply Dr. Palmer's racially polarized voting analysis to do exactly what Brian identified, which is look at the racial makeup of districts, look at the racial makeup of adjoining districts, and see if there's racially polarized voting in such areas that would justify perhaps creating 2 districts where you previously had 1. I think that's what Brian was saying. Sorry.
I don't have any problem with changing that as Jerry has indicated. I think, and this may be assumed already in what we're saying on the no prohibition language, but the no prohibition on creating coalition districts, I think, still has to be, while otherwise following the commission's guidelines and guidance, which I think that's probably assumed, but just wanted to make sure that was clear as well.
Yeah, I'm hoping that would be in everything that we do. So, Chris?
Yeah, just to underline that point, I think what Brian is saying is that the map drawers need to follow the commission guidelines in the order of priority that they're set out, including the duty to maintain existing political subdivisions. So while there's no prohibition on creating a coalition district, you can't do that at the expense of following the higher priority criteria, including following your political subdivisions. I think that's the point here.
Okay, Dr. Creighton?
I just want to offer the bookmark to say, I think that's a topic we want to come back to, the priority conversation, but I think it's not objectionable to have a reminder about map drawers following the overall guidelines that the commission has otherwise given us.
Okay, all right. Delegate Simon, you have your hand up.
Well, I think that if you say that you're not going to consider coalition districts ahead of other criteria, then you're relegating them to a lower status than Mr. Hebert and Mr. Creighton, Dr. Creighton said we could do. I thought Yeah, I think you ought to be able to. I guess the opposite of what Mr. Bartolomucci said. I think you ought to be able, if it's possible to do that, I think you ought to be able to deviate from some of the other criteria. So.
Okay,
And maybe the minority, but
Delegate
Madam Chairman.
Adams?
Well, I mean, in response to that point, I understood that race could not be the predominant factor. You'd run afoul of the equal protection clause. And so I thought that's why the explanation is, follow the guidance in the order of priority as laid out.
Which we are. We laid out our criteria in priority order going from constitutional mandates, which the Voting Rights Act is above some of the other criteria like communities of interest. So we've already laid that out, and I don't see that being in conflict because the Voting Rights Act is a constitutional consideration that, in my mind, is higher than some of the other criteria that we have. Chris?
Yeah, thank you, Madam Co-Chair. But I think the point here is that Jerry is not saying that coalition districts are required by the Voting Rights Act, but we should it's permissible to create them. But under our criteria, there's Voting Rights Act compliance, near the top, and below that there's maintaining existing political subdivisions. To the extent that coalition districts are nice, desirable, but not required by the Voting Rights Act, they would have to go below the duty to maintain political subdivisions.
Okay, Dr. Creighton?
Okay. Let me start, if I may,
Okay,
Madam
yes,
Chair.
yes.
First of all, I am saying that coalition districts are required by the Voting Rights Act if the two groups vote in a politically cohesive way, because they're meeting the jingles prong. I don't believe, however, that a coalition, a crossover district, as defined in Bartlett, is required under Section 2 for the reasons set forth by the Supreme Court in Bartlett. I would say also, though, on this whole general topic we're talking about, that don't forget that in addition to Section 2 of the Voting Rights Act, we also have a state Voting Rights Act that was just referenced, which states a violation is established if it is shown that racially polarized voting occurs in local elections, and that this, in combination with the method of election, dilutes the voting strength of members of a protected class. For purposes of this subsection, racially polarized voting refers to the extent to which the candidate preference of members of the protected class and other voters in the jurisdiction have differed in recent elections for the office at issue and other offices in which the voters have been presented with a choice between candidates who are members of the protected class and candidates who are not members of the protected class. A finding of racially polarized voting or a violation of subsection A shall not be precluded by the fact that members of a protected class are not geographically compact or concentrated in a locality. Now, that's a lot, but I will just say that the map drawers are presumably instructed to comply with federal law and state law, including the provisions of the Virginia Voting Rights Act. And so I think that we're simply saying that if you draw a district and it turns out to be a coalition district where two minorities are combined, that's not, you're not prohibited from doing that if that's what naturally emerges. And I will say in response to Delegate Adams' point that I think that this is largely a moot question because I think it was Delegate Adams, yes.
In the mic.
That it was, that this is largely going to be an academic discussion because I think that when you're looking at a minority group, that minority group may well emerge very consistent in geographic area with a community of interest. There may be neighborhoods that say, this is our community of interest, or this is our area that we believe should be not divided. And so when you put that in, it may well combine with another group to create this. I think we get way ahead of ourselves if we try to anticipate every possible iteration at this juncture and instead just give the map drawers these instructions, which it seems like both sides agree.
Madam Chairman.
Yeah. Okay, Senator McDougal.
That last statement seemed logical to me, saying let the map drawers, if they're drawing the districts and then the districts are created that are the combination districts, there's no prohibition, there's no requirement. But some of the rest of what I'm hearing is from Mr. Hebert is saying that we have to have a requirement. So that's the part that concerns me. I'm very good with saying no prohibition, no requirement. If the district gets drawn that way, the district gets drawn that way. Some of the other things that I'm hearing Mr. Hebert say sound like he's saying, and there's a requirement. So that's where I'm getting confused in the list of items that he's asked us to.
Okay. All right,
to vote.
Delegate Simon, and we're down to about half an hour or so because we really do have other areas we need to cover, but we're getting closer, which is great. Okay, Delegate Simon?
So I get it. I get two things I want to say then. One is, I don't want to leave here with a misunderstanding, however. I know we're in a hurry, but I know that some of us thought that the map drawers would be taking a look at incumbent addresses because we said they may do it, and some of us heard may means you can't. And so here we're talking about a situation where we're saying we may have these districts, but I don't want to have a map come back that says, well, we said may, but we didn't mean that they should actually do it that way. So I'm just trying to make sure we got some clarity when we start. Every time it's a permissible but not required thing, I don't want to leave here with a misunderstanding about what's happening. So I agree with Senator McDougal on that. We ought to know clearly if it's a requirement or not. And then the second thing is, I think what I heard Mr. Hebert reading from the Virginia Voting Rights Act, the last sentence that he did suggested that compliance with these provisions really should come before worrying about political subdivisions. So, I mean, it says, irrespective of whether they cross, these groups cross localities, was I think the word they use. But it seems to me that under state law, we ought to be looking at this before we're looking at political subdivisions, if based on what he just read. So those would be my two observations. But I'd like to I know we need to move on, but I want to make sure that when we come back, we don't come back to a different, surprised about how the maps turned out because we thought we were given two different sets of instructions.
All right, so it sounds like we aren't that far apart, and I'm wondering if between Delegate Simon or Senator McDougal, I'm actually looking for a motion to something to this effect as additional guidance to the map drawers, that once they follow our criteria and they have their first round of statewide House and Senate maps, that we're asking them to then utilize Dr. Palmer's analysis to look at the racial makeup of districts and adjacent districts to see what the data shows. And that's one motion, that we're asking them to use that analysis, and then as part of their presentation next week, to flag for us those districts where racial polarized voting has occurred and give us the data around the racial makeup of those districts and the districts that are adjacent. Does that help give clarity to the map drawers if we made that vote? And I'm looking at the attorneys for some clarity on that.
I think it gives guidance. I think that's a start, yes.
And I have one more thing after that. Chris or Brian?
I would agree as well. I mean, I think that basically instructing them to look at the racial polarization analysis to inform their drawing in those particular areas where there is racially polarized voting, I think that is helpful to them.
Okay. So does anyone want to try to make a motion to that end?
I don't know how much that moves the ball forward beyond where we were when we got here.
Well,
I'm sorry. I hate to, but I think we always knew they were going to be looking at the racially polarized data. The question is what we want them to do with it. So my motion would be something along the lines of that they look at racially polarized voting and where opportunities exist to create districts that allow for minority opportunity districts, including coalition districts, that the map drawers should endeavor to create such districts. That'd be something along those lines would be my direction.
Madam Chairman,
Yes.
if I understood, that's where the attorneys disagree in their interpretation. Mr. Hebert says that that's what you need to do under the Voting Rights Act, and Mr. Tyson says if you do that, because you're basing your decisions on race, that would require strict scrutiny and could put you in violation of the 14th Amendment. Is that the two different legal opinions that I heard?
Well, let me restate it because it's not quite right. And it's not quite right, not because of what you've said, but because while I believe that Section 2 permits, and in fact in cases requires the combination of two or more groups to vote in coalition in a majority-minority district, that's not what we're requiring the map drawers to do to create coalition districts. It's simply that they are not required to do it, but it's not prohibited to do it. That if they have, for example, looking at an area and they've got African Americans and Latinos side by side, and they come up with a district that's 45% black, and they can add Latinos to get it over 50% and they're cohesive, then I think that map drawers should be permitted to come forward and say, this is what I did in this district and here's why I did it. And I think they should be required on both sides of the aisle to draw and explain to you, commissioners, every district they drew and why they configured it the way they did.
Okay, all right, Chris, and then we'll go to Meg.
Sure, quickly, the Republican position would be that Jerry's theory has never been endorsed by the Supreme Court in holdings. I think Jerry would be the first person to admit that. The Republican position would be follow the guidelines, use traditional redistricting criteria. If that results naturally in the creation of minority opportunity districts, fine, so be it. But that it creates litigation risk if the map drawers are instructed to go forth and try to create minority opportunity districts in disregard of the guidelines and the traditional criteria.
Madam
Meg?
Chair,
Yes.
staff would like to suggest that the vote be on that issue. I think everyone is in agreement on all the other pieces, but I think we might just need to make a motion to either go with this or go with this, and then we see what happens. But I think we're talking in circles of each other, and I think everyone is correct in saying that the map drawers need a little bit more specific instructions than just look at our RPV analysis.
Do you have any suggested language as to what a motion could be?
You could make a motion to say that where opportunities exist for minority-majority districts, including coalition districts, the map drawers are instructed to do so. And then if people are opposed, they vote no, and if they are in support, they vote yes.
Madam Chair, I would adopt that language as my motion, since Meg's not a member of the commission. I would make that motion.
Okay, is there a second?
Seconded.
Okay, and
Madam
so
Chairman.
can you?
Thirded.
Hold on, okay. Can you repeat that one more time, Meg, so that we can all be clear?
To instruct the map drawers that based on the RPV analysis done by Dr. Palmer, that where opportunities exist for minority-majority districts, including coalition districts, the map drawer shall endeavor to draw, or shall draw those districts.
Thank you so much.
Madam
Okay. Who was that?
McDougall.
Oh, okay, yes.
So, Madam Chairman, so going back to what Mr. Tyson, Mr. Hebert said. So under Mr. Hebert's analysis, if we instruct them to do that, he thinks that that does not run afoul of the 14th Amendment and the Voting Rights Act. Mr. Tyson believes that if we instruct them to do that, because we're making a decision based on race that is not required under the Voting Rights Act, that would put us afoul of the 14th Amendment and would be impermissible. So this motion specifically means that we're going to either be sued, we're going to get sued one way or the other. But
Already been down that path.
one council is saying we specifically can't do this, and one council is saying we specifically have to do this. That's what I heard. That's what I want each attorney to tell me. Did you specifically say you can do this the way the motion stated, or that you specifically can't do it the way the motion stated?
Maybe just a yes/no answer.
Senator McDougall, you've accurately captured our analysis from our side that you're walking into an equal protection violation if you give that instruction.
We're just asking the map drawers to draw the map. You're not voting on the final map here to create the coalition districts. Simply, let's look and see if they exist.
Madam
So the
Chairman.
answer is yes. I do think that there's a difference of opinion. And I would say that all the circuits that have addressed this issue, except for the 6th, have said coalition districts are permissible and required under Section 2 of the Voting Rights Act.
All right,
The
let's
Supreme Court
call
has
the
not-
vote,
Chairman.
please.
Madam
Let's-
Chairman?
Yes.
I guess
Senator McDougal.
specifically, Mr. Hebert, the question is that it's not, can you do it? We're now, by this vote, we'd be requiring the map drawers to do it. It might not be the final maps that we're coming up with, but we're giving, as a commission, specific direction to say race is a predominant factor in your decision.
It is a factor.
Not
is-
with this motion.
Madam Chair?
This motion says it is,
Madam
you
Chair?
have to draw it that way.
Yeah.
And so that's the question I'm asking Mr. Hebert to answer, which I don't think that's what you just answered. This is saying, if you have the ability to do it, you have to do it. Is that what you're saying? Because that says race is the factor that you're making the decision on.
If, yes, if you have politically cohesive groups that are near each other geographically, compact, such districts are required under Section 2 of the Voting Rights Act. It may also be required under the Virginia redistricting, Virginia Voting Rights
All
Act.
right, Senator Barker, and then we're going to call the vote, please. Senator Barker?
Madam Chair, I agree actually to a certain extent with Senator McDougal in terms of what the language says. What I would propose is to change the word shall to the word may in that last part of the staff recommendation of the motion.
Madam Chair, if that's a motion, I second that motion. There's a substitute motion.
Okay. All right, so Mick, can we just read it one more time? Well, do we have to vote on the change from shall to may? Or can we just do one vote?
Yeah, if someone would like to do a substitute motion and someone second it, then I'll read a motion that has may instead of
Okay,
shall.
so I think Senator Barker did a substitute.
I'll make that as a substitute motion.
All right, and Mr. Kumar second. So now we're voting with the updated language.
So to
with may.
direct the map drawers to utilize the racially polarized voting analysis to look out where opportunities exist for minority-majority districts, including coalition districts, and where they do, they may draw them.
Madam Chair?
Thank you. Yes.
Speaking to the motion briefly, I'm going to vote no, and it's not because I don't want them to draw the districts. I just don't want anybody to misunderstand. When we tell them they may do something, we haven't told them anything at all, is my position. So we're going to, after almost 2 hours and 15 minutes of conversation, the map drawers are going to have no more guidance than they had before we started, because you can tell them they can do something, but they don't have to. And so I don't think we've really accomplished anything with this motion, so I'll be voting no.
All right, so we're going to vote on the substitute motion, and then we'll come back to the original motion, okay? So let's vote on that.
Mr. Abrinio.
No.
Mr. Hutchins.
No.
Mr. Kumar.
Yes.
Mr. Feliciano.
Yes.
Mrs. Trost Thornton.
Yes. Yes.
Yes, okay. Mr. Harrell.
Yes.
Delegate Adams.
Yes.
Senator McDougal. Delegate Ranson.
Yes.
Senator Stanley.
No.
Senator Barker.
Yes.
Senator Locke.
No.
Delegate McQuinn. No. Delegate Simon.
No.
Madam Co-Chair Harris.
No.
Madam Co-Chair Babachenko.
No.
It was 9 noes, 7 yeas. So the motion fails.
Okay.
So now we're going to go back to shall.
Yes. Okay, and if we could call that vote, please.
Mr. Abrinio.
Yes.
Mr. Hutchins.
Yes.
Mr. Kumar. Mr. Kumar.
I vote no.
Mr. Feliciano.
No.
Mrs. Trost Thornton. Mrs. Trost Thornton. Abstain? Mr. Harrell?
No.
Delegate Adams?
No.
Senator McDougal?
No.
No. Delegate Ranson?
No.
Senator Stanley?
No.
Senator Barker?
Yes.
Senator Locke?
Yes.
Delegate McQuinn?
Yes.
Delegate Simon?
Yes.
Madam Co-Chair Babichenko?
No.
Madam Co-Chair Harris?
Yes.
7, 1, 2, 3, 4, 5, 6, 7, 8. 7 yeas, 8 noes. So it fails.
Okay, so we're right at the beginning again with no additional guidance to the map drawers at this point. Okay, I'm going to table this, and then Mackenzie, you'll have it on Wednesday. Honestly, we have 3 other items, and we're going to stop at 20 till 4 because we have almost 10 people who have signed up to speak. So we have 25 minutes to quickly go over political subdivisions, communities of interest, and partisan equity. And my understanding is that the 2 legal counsels agree on all of that. And what I would ask, everybody can read your memo. Tell us what guidance we should be voting on to give more specificity to the map drawers. We can read what you've written. Please give us what is it that we should be voting on to give the map drawers more instruction. And then I will say that on Wednesday, we have a full agenda then, but we need to figure out what we're all comfortable with as it relates to the Voting Rights Act. Yes.
Madam Co-Chair,
Yes, Ms. Co-Chair.
This is Mackenzie Babichenko. In anticipation for that Wednesday meeting, perhaps everyone can consider, I know everyone just got this document today. We have a lot of information. Think about language that you might like. Some of that I think it was hard to vote yes because maybe we just weren't sold on the actual language, but there could be some language that we all agree on so we can give that guidance to the map drawers. I think there were some similarities in additional things that maybe not that specific issue, but things that we certainly can agree on that were referenced by both counsel. So consider that and bring that, and maybe we can have some more motions on that day with some, everybody can get some sleep on the issues and see where you are then after you digest all this.
Right, and Meg, I would also ask that you guys send that draft language. You can put shall and then may in parentheses, but send it out to all of the commission members so that we can mull over that. Because I think we boil it down to one thing. We just need to get comfortable with what an actual motion is that could give more guidance. So.
And Madam Co-Chair, with your permission, I would like
Yes.
to be able to work with the attorneys to make sure that I'm accurately describing what they
Yes.
believe the motion
Yes,
should be in motion.
absolutely. And the co-chairs will probably sit in on some of that as well, too. Okay, thank you. Thank you very much. Okay, who is presenting the political subdivision section? In 50 words or less. I love that. Yes. So who is that? Okay, Dr. Creighton, thank you.
Thanks, Madam Co-Chair. In the interest of time, I'll try to limit our discussion so that we can get right to the nub of it. I think on things that we agree on, I think it's probably 80 to 90%, although maybe the other piece is important. I think we agree that political subdivisions are important. They're reflected in the law. They're reflected in the commission guidance. We, I think, also agree on the definition of a political subdivision, and I think you'll have a document that lays that out. And I think the thing that we also really want to focus on for this conversation is the question about priority. I think we've taken the view that we all agree that there's a priority difference between guidance that comes from the Constitution and statutes, and then we get, obviously, to policy questions that reflect the Commission's guidance. I think where there's a difference, and it's something that was sort of, it's reflected in earlier documents that the commission has seen. We sort of left this an open matter as to whether we're approaching the commission's guidance in order of priority. We heard Chris earlier talk about the sort of listing of factors that the commission has talked about in terms of what it guides after you get down to the nub of how to think about things like the compactness of communities of interest, et cetera, in a particular priority. Our reflection on the conversation that the commission had in adopting the guidelines suggested that questions about how the division of subdivisions, how the breaking a subdivision fits into the other factors was sort of an open question. Let me be more specific about what I mean. There was a question as to whether or not, for example, in Northern Virginia, the division of Alexandria should be something that happens should be prohibited as a matter of course, or whether in certain instances where, say, public input says, look, we want to be divided in the city of Alexandria, whether the commission should take that into account. Our view is that it will matter in terms of context, so we would actually encourage the commission to think about this not in terms of a hard and fast priority, but instead, as you go region by region in the state, think carefully about the way in which adherence to subdivision makes sense or not. Partly guided by public input, but other factors as well. So we would differ as to, I think, the bottom part. I'm sorry, I'm not looking at the document right now, but there's a latter part of the directive that gives a priority to the types of subdivisions that should be protected in order of priority. Our view is that there may be some places where you would want to prioritize counties, others where you want to maybe put a, if the choice is to divide a county or a independent city, there may be reasons to choose the independent city. But one should not constrain the map drawers at this point into this sort of list of priority. And I should also add that, of course, the way you approach that might differ depending on the part of the state that you're in. Some parts of the state have more independent cities than others, and the way in which the public actually sees the protection of an independent city might be just very different from region to region. So we would like to preserve that. So with respect to the question about priority, we sort of put a bracket around that, but otherwise respect the notion of what political subdivisions are, that they're important, and to instruct the map drawers generally where they should, where they can, to protect subdivisions, but obviously be guided by the public input as to whether or not in a particular area one takes a certain priority of, say, one type of political subdivision over another.
So
Madam Chairman.
Dr. Creighton, it's a point of clarity. So are you recommending prioritization as what the guidance, starting with potentially counties, independent cities, towns, and it could even go into special purpose districts, but I'm trying to clarify how we want to give guidance to the map drawers on that.
So our position, I think we differ about this to be clear. Our position would be that generally speaking, one should not prioritize one set of subdivisions over the other, except by guidance that you get looking at the public input and thinking about the part of the Commonwealth that you happen to be located in. So we on the Democratic side would not be very supportive of the idea of prioritizing them hard and fast across the state.
Okay, all right. Senator McDougal?
Is there specific language? I know we got the sheet when we sat down in here that apparently was mailed out 30 minutes before the meeting started. Are the words that you're proposing on this? Because I'm looking at things that say school district, utility districts, community college districts. I don't think we have any of those in Virginia. So I'm trying to figure out what language we're actually talking about.
So we offered various examples of subdivisions, and the point is simply that those are possible ways of defining them. They may not be ones that are used, but we want to give the ability of the map drawers to look at the different subdivisions that may exist and give them consideration in whether to kind of keep them whole in a district. So there's no hard, fast rule about how to do it or which subdivisions to prioritize, but instead just to say, we're giving you basic guidance about the kinds of subdivisions that exist, If you'd like to find others, feel free, but state what they are. But there's not going to be a hard and fast rule about, say, prioritizing in a certain jurisdiction a city boundary over, say, a county boundary. We do prohibit, by the way, the election districts within those areas because we think they could be, just as we've stated at the commission level with state legislative districts, subject to political manipulation. And so we would prohibit that unless we see specific guidance in the public input from, you know, a community that says we actually like being in this particular election district. We'd like to see it reflected in a boundary that's drafted by the commission.
Okay, Delegate Simon?
So, Madam Chair, I like the idea of adding some more guidance. I agree sort of with Senator McDougal, though, that we ought to figure out some ones that really exist. For instance, we have planning districts in Virginia. And so like planning district 8 is well-defined and everybody knows where it is. And I think it might help, like the decision on Northern Virginia last week about which direction to go with Loudoun, right? You couldn't divide Loudoun but so many ways. So do you go west or do you go east? I think having information about a planning district would help. And it also makes sense because those jurisdictions are used to collaborating on planning issues. We also have special tax districts in Fairfax. You know, we have a special small tax districts. And again, given that people there, you know, vote on a board of governors and things like that for their special tax districts. So I think if we could come up with a list of additional subdivisions for people to start considering, I think that would probably be helpful because I think just the county, city, town thing and being too wedded to that, I think we could see with some of the maps we got was causing some problems. So I would encourage us to do that, but I think we could probably give them a list of some. I know that in DLS they draw, when we're trying to avoid special legislation, we use planning districts a lot. We have a lot of different ways to carve things up. So I'm sure there's some sort of list that we could give to the council to help them define that. But I think it's a good idea generally to add more so that they have something else to rely on. And I also would agree with Dr. Clayton about use those as your justification, but I don't know that prioritizing one over the other matters a whole lot.
Okay, Delegate McQuinn?
Thank you, Madam I could have said Madam Speaker, Madam Chair. I mean, I agree with Delegate Simon, but also because as we were talking, I was thinking about some of the district that I represent, and I have four housing development, and we want to make sure that I guess they could be considered a subdivision, a political subdivision, and certainly we want to keep those intact, even if we don't just make sure that all of those, the one intact, but there are several of them that are so close to one another, in close proximity to one another.
So am I hearing that maybe also on Wednesday, that we ask members to come with additional districts, as you all define it, that can be listed potentially for the map drawers to consider? Yes, Dr. Creighton.
I just want to make sure everybody is clear about the listing of these were intended to be illustrative and not exhaustive. So if the commission desires to have an exhaustive list, we're happy to go that way. But what we were hoping was for sort of an example that gives some guidance to the map drawers and also leaves open the possibility that they may choose any of these others. And I think the suggestions are great and they're useful. But I also want to make sure that, you know, we're not using too much energy about trying to have an exhaustive list.
Yeah.
Because that could create problems. But if that's what the commission wills, that's perfectly fine.
Madam Chairman, I guess I'm hearing this, and I'm sure different people think their areas are very important. In my area, Delegate Ranson's area, the northern neck is very important. If you ask somebody where that is, some people will say that ends at Westmoreland, some people at King George, some people might even say Richmond County. So they think that that's more important, and I almost guarantee you to a person, unless they're on it, nobody knows where the planning district is, because even though that might be a political subdivision, they don't know where it is and which counties are in it. Same conversation comes to the Middle Peninsula. Some people in the Middle Peninsula think that's very important that they're in the Middle Peninsula. Some people that are in a county like King and Queen, at the upper end of King and Queen in Newtown, don't know where the Middle Peninsula is because they're so far away from it. Doesn't really matter to them. So if we're going to start listing out things, in my mind, what we had all thought we were, at least what I thought we were talking about, were counties, independent cities, and towns, because they were defined and specific. The area that I live in, we all call Mechanicsville, or we all call Old Church. We all know where that is. Some people feel that that's very important, but it's not an independent city and it's not an independent town, so it wouldn't be considered. If we're going to be more, if we're going to broaden up the list, then I think some of us are going to feel like we have to be very prescriptive and are want to know what they are and probably vote on that. I probably would not be comfortable with the planning district being the political subdivision. Delegate Simon might be.
So, but we can all acknowledge that Virginia's a big state, and there are lots of different nuances depending on which section of the state you want to be on. So again, Dr. Creighton or Chris, and what I'm trying to do is get specific. What is it that we need to give the map drawers to help them in giving them guidance as to how they go about doing their work? It's saying don't name the specific subdivisions, or we could have an exhaustive list, or how do we give them guidance and not confuse the issue? And I think, Mr. Harrell, you had your hand up too, if you wanted to speak.
I just got one point. I think we're confusing the issue. I think we're just adding all these different possible things, and no one human map drawer could prioritize all these things. I just think we tell them political subdivisions, and I think they're both smart enough to handle that.
Okay, Sean?
Madam Chair, I mean, unless I'm misunderstanding, I think is this one-page document on political subdivisions specifically, I thought was council's agreed intent. So if there's consensus to give this general guidance, and they've given us in this, some guidance to give them with proposed language, and I think if there's consensus on that, we just adopt this as a list of examples, right? And then they've heard our discussion. They, as Mr. Harrell said, they're going to be able to figure it out. But I think the guidance in this document, if council thinks us voting on this or something like it would be helpful, then I would move that we adopt the language that in this document that both council have agreed to.
Is there a second?
Madam Chairman?
Yep.
I hope council did not propose a document that included special purpose districts, school districts, utility districts, and community college districts that we don't have in Virginia.
Well, we do have school districts.
Madam Chairman, we have counties and cities, but we do not have independent school districts. Huh?
Okay.
You have a,
Could there be a line amendment to just strike the parenthetical school districts, utility districts, and community college districts? And
I was reading it as examples,
Yeah,
this is not definitive, and.
But,
if
including but not
exists-
limited to, at all.
Madam Chair?
Yes.
Madam Chair?
Yes, Senator Barker.
Yes, I would be in favor of not having anything referencing all these examples or potential examples of additional, public entities. Because in most instances, I don't think they are political subdivisions, if not all of these that are listed here. And it seems to me that these could be something that could be covered in the section on communities of interest, rather than being stuck into political subdivisions.
So Sean, would you be interested in amending your motion such that if we take out the things in parentheses?
I'd be fine with that, or we roll it in, but what I was trying to avoid is that we move this to another meeting and
I
add
know.
yet more
We're
examples
yep.
and words to go into it.
Okay. Yes, Dr. Creighton.
I'm sorry to make this more difficult, but I do think there is a distinction between the way our two sides approach that question about subdivisions, and it is just on the question as to whether or not there is a priority order of how those subdivisions ought to be protected. We view it as not having a priority. The Republicans in their language would prefer to have in a particular priority, I think.
I see. Yes, Chris?
Madam Co-Chair, I was going to suggest that I think that the sets of council are very close on this document, and we could go back and take the input we've received today and probably come back Wednesday with a document that's 100% agreed to between the council and also reflects what we've heard today. And that
Okay.
may make a vote a little easier.
All right. Mackenzie, so can we maybe table the motion, and then that's two things on Wednesday. You guys are going to come back together and quick voting on Wednesday, because we have other public input that we need to talk about.
Madam
Yes.
Co-Chair, may I, or Madam Chair today? Can I
Yes.
ask a follow-up question? Can we get that document sooner rather than later so that,
Like tomorrow?
yes, when you guys are done, and so that people have time to read it, and then we will have a better likelihood of a quick vote. Thank you.
Okay. All right. Meg, did you?
For the other two that we have, communities of interest and political equity, am I correct in assuming that you all are not in 100% agreement on those two either? And if that's the case, can you also work to come up with something that you 100% agree on for everyone to vote on Wednesday?
Let's talk about it.
If you are in 100% agreement, can we vote? And if you're not?
Okay. All right.
Help me help them, please.
And what I see is the document, the memo, which is really great, is background, is helping to educate all of us to understand the complexities of each of these issues. But what we're wanting is a statement. Boil it down. Here's the background. You already have that. And boil down a statement that we can vote on that is specific guidance to the map drawers. Okay? That's what we're asking legal counsel to do. Yes, Chris?
Again, Madam Co-Chair, I think we're very, very close to each other on these other two documents. And what we could do is subdivide them into sort of a general background section and then a section on specific guidance
Yes.
to the map drawers. Would that be
Yes.
helpful to the commission?
That would be super helpful, and Mackenzie's jumping up and down over here now. So, because we're going to put it up and we're going to vote on stuff really quickly and early on Wednesday because we have a lot of other things to do. And we want to give enough time to the map drawers so that next Monday, we actually have some meaty stuff to look at with the maps, okay? And we appreciate all the dialogue and input. All right, Delegate Simon and Senator Stanley, and then we have.
Again, if we can get those motions sooner rather than later, I think we're legislators, we're used to chewing over these things, and frankly, if we're going to vote on it, I mean, the words do matter. And I know that as much as you'd love for us to just defer to our counsel on these things, I think the sooner we can get it, and maybe Senator McDougal and I can get together before the meeting, and see if we can't make sure we're all together as well. I think that just might speed things along on Wednesday.
So our meeting on Wednesday is at 8 a.m. How far in advance would you all like to have that document so we can give them?
7:30.
7:30 in the morning? 7? 5 p.m. the day before?
The day before, Madam Chair, would be.
Yeah.
Yeah, that's tomorrow.
Yes, tomorrow. Yeah.
So if you all can get that to staff by 5 p.m. tomorrow, then we can send it out to the commission right away.
Okay.
So Madam Chair, 5 p.m.
5 p.m. on Tuesday.
All right, Sean Kumar, please.
Yeah, Madam Chair, thanks quickly, and sorry I don't want to risk complicating it more, but I think we're also going to have to decide on the order of criteria, right? Because the criteria alone without order of precedence in a matter like this will probably also matter. And if that's something that council can try to address, I imagine it's going to need to be done. We're going to have to give direction as to order political subdivisions before political equity and whatnot, if it's not already ingrained in the criteria.
And maybe we need to vote on that, but the way it's listed, we went with constitutional things, with
Got it.
Voting Rights Act, and then down to political subdivisions, communities of interest, and partisan equity being last.
If we've already got
Okay,
it, then
all right.
never mind.
And James?
Hopefully, I'm not going too out of order, but I think at some point I would like to address Moon-Duchin and whether or not we are going to, as a commission, want her on board. So,
Okay, hold on one second, and let's wrap up here with Senator Stanley.
And thank you, Madam Chair, Senator Bill Stanley. On the political equity issue, my only concern, and that may be something that I hate to get in the middle of two attorneys trying to resolve issues, but as an attorney, I've been there. So in the last paragraph, of course, we talked about last time at the meeting the issue of incumbency and whether to use or not use it. And of course, this recommends not using incumbents' addresses in the determination of these maps. What do we then do? And maybe you guys can work this out to to unwind what has already had, where those incumbent addresses have been considered already in map drawing in one way or the other for either map. Thank you, Madam Chair.
Okay, thank you. All right. James, is it possible that we can talk about your issue maybe on Wednesday?
I'm fine with that. I just want to make sure the longer we wait, then all of a sudden it becomes moot. So just wanted to make sure that was in the queue.
Okay, all right.
Thank you.
And we can talk about that, and I think, we want to allow a little bit, well, enough time here for our citizen comments. And Meg?
Let you all know we have 5 people still signed up to speak
Okay.
virtually.
Okay, thank you. All right, so let's see. If our speakers are either on the phone or on the Zoom meeting, our first speaker would be Chris DeRosa. Please.
Madam Chair, this is Shay.
Yes.
That person's not here.
Okay, all right. Our next person would be Monica Sarmiento, and I apologize if I misstated your name.
It's quite all right. Thank you so much, Madam Chairwoman.
Thank you.
Good afternoon, members of the Commissioner. My name is Monica Sarmiento, and I'm the Executive Director for the Virginia Coalition for Immigrant Rights, a multiracial and multi-ethnic coalition of organizations that exist to win the dignity, power, and quality of life for all immigrants and refugee communities. The series of 501c3 nonprofit, nonpartisan coalition of 43 organizational members. Members of the Commission, on multiple occasions I have testified urging that the map drawn be fair and provide all immigrant communities with fair and equitable representation. The Latinx community makes up the largest immigrant population in Virginia at 10.5 of the overall population of the Commonwealth, with 828,000 Latinx community members call Virginia home, making this population the 16th largest Latinx population in the United States. Virginia boasts a larger Latinx community than Maryland, Washington, D.C., and West Virginia combined. The current proposed map has divided historically known Latinx communities, effectively diluting their voting bloc and diminishing this community's of interest ability to elect legislators who can provide equitable representation in the General Assembly. For example, the Columbia Pike Fairfax community has been splintered. The Latinx community faces unique challenges which merit equitable representation. In the last year, we have seen the Latinx community suffer the highest rates of COVID-19 infection rates compared to the general population, endure higher rates of financial hardship from the pandemic due to the large rates of unemployment, and regularly face language barriers. These are just a few of the hurdles that the Virginia Latinx community faces. Members of the Commission, I urge you to draw a proposed map that keeps the Latin voting blocks together. Thank you.
Thank you very much. We appreciate your comments.
Thank you.
Our next speaker is
Excuse me, Madam Chair.
Yes.
Christine DeRosa is now on.
Oh,
She just joined.
All right. Chris, thank you for being here.
Hi, I'm Chris, and I think I unmuted myself.
Yes, we can hear you.
I don't know how to control my camera. Anyway,
Okay.
thank you for allowing me to speak today virtually rather than in person. I appreciate that change, and I appreciate the adjustment of the sign-up deadline to 10 a.m. rather than yesterday at 1. That helps a lot of us. I hope you will also consider rescheduling a few of your public hearings in October so that they might be held after the normal workday. There are many people who would like to talk with the commission, but because they work full-time, they cannot attend these daytime meetings. I do want to thank you all again for working on this complicated, demanding issue. I want to thank the co-chairs for their leadership. You've demonstrated great leadership skills, and I applaud the way that you're working together to steer this ship on its sometimes bumpy, very unique journey. I want to thank the map drawers who I think have done an admirable job drawing the first set of draft maps for the Northern Virginia region. I and many other Virginians applaud your efforts to keep cities together rather than splitting them among districts, as well as your efforts to respect county boundaries as much as possible. Already the draft maps look so much better than the current maps, and we look forward to seeing the full maps next week. On another note, I must express my disheartened feelings that when I heard 3 different commissioners describing many commenters, including myself, as only a few of the engaged people, and suggesting that our comments should be ignored or dismissed. Yes, I proudly admit that I'm one of the engaged and passionate core of citizen members. But may I remind you that we are Virginians and we are your constituents. Besides participating directly in this process, most of us have tried to inform the greater public about the commission, its website, and its meetings. Considering the lackluster outreach and publicity by this commission for the past 8 months, the number of participants would have been far, far fewer without the efforts of the groups, many groups, nonpartisan and nonprofit, who have been really trying to reach the public. I ask that this commission try to demonstrate greater respect for we the people. I'll continue to devote 20 or more hours every week, for which I get paid not 1 penny, to this effort to create fair maps and encourage other Virginians to engage in the process. I stand ready with you to help. Thank you.
Thank you, Chris, and we appreciate all of your efforts. The public feedback and comment is important to this commission and will be an ongoing part of our final decision-making for the new maps for the Commonwealth. Thank you. Our next speaker is Paul Berry, unless Shay tells me otherwise.
Good afternoon. I think everyone can hear me.
Yes, thanks,
good
Mr.
afternoon,
Berry.
everyone. Thank you, Madam Chair. My name is Paul Berry. I live in Fairfax County. Thank you for the opportunity to again add public comment to the DRC. I chair the Governor's Latino Advisory Board, and I also chair the Fairfax County Redistricting Commission. Today, I'm here in my personal capacity. Much of what I wanted to say was said by Ms. Sarmiento. The Latino community has been diluted in a number of places, unfortunately, with the current map drafts. An example, districts 2 and 3 of the B2 NOVA maps, that's 2 and 3, split the Columbia Pike community that traditionally has had a lot of cohesiveness and could certainly be considered a community of interest. District 18 of the B2 NOVA maps, the same set, dilutes the vote power of the town of Herndon, a majority-minority Latino area. In this B2 version, Herndon joins with an area to the east, namely Reston, that consistently records some of the highest voter turnout by precinct in the entire state. That makes it difficult for Herndon residents to reasonably expect to exercise an effective voting strategy for a preferred candidate. Look no further than the current representation of both Herndon and the Reston areas for proof of this. The current district that includes Herndon elects candidates that are very different from the neighboring district. This map would not pass the first and third Jingles tests. Latinos aren't just at risk here, as I mentioned in Arlington. Both draft versions, unfortunately, eliminate the only 2 Latino legislators in Virginia's history from their districts. And I'm asking that special consideration be made to include them in a way that retains what little representation Latinos have in the General Assembly. The seniority of these 2 legislators represents the only political currency of any kind in the General Assembly for the aforementioned 828,000 Latino Virginians. State and national Latino organizations are discussing legal strategies specific to the Virginia redistricting process related to Voting Rights Act violations if these maps move forward. They will share their concerns in the coming days and weeks around Latino vote dilution, as I've mentioned, and the negative impact on equal representation. In short, if these 2 legislators are drawn out of their districts as proposed in these drafts, the ability for the Latino community to have a voice in civic life will drop to nothing. Thank you again. I sympathize with the dilemma of public outreach. We at the Fairfax level have had our own difficulties there, and I want to thank you for your service and for the contributions that you're making to this very complex process.
Thank you, Mr. Berry. And again, we'll reiterate that this is an iterative process. There we go. And that the maps that were shown last week first shot out of the gate, and they will change. And we just
Madam-
appreciate the feedback, and that will influence our final decisions. So
Madam
thank
Chair,
you.
there was also an error in the appendix of the materials that I forgot to mention. District 49 has 24% Hispanic VAP, and it is not currently listed in that appendix.
Okay, thank you so much for capturing all of that information. Our next speaker is Jason Stanford.
Hi, can you hear me?
Yes, Mr. Stanford, thank you for being here.
Great, thank you. Hi, my name is Jason Stanford, and I live in the Douglas Park neighborhood of South Arlington. Thank you for the opportunity to comment today on the newly proposed House of Delegates boundaries for Northern Virginia. I chose to comment today because, frankly, all of the House district options you put forward for my neighborhood, I believe, lack a nuanced understanding of my community. The Columbia Pike Corridor in South Arlington is one of the most diverse and working class communities in Northern Virginia. We're currently represented almost completely by one member of the House of Delegates. All of the options put forward would split that community into districts that are primarily represented by other communities of interest. North Arlington and South Arlington, divided along Route 50, are very different communities. The fact that Arlington County has nearly 240,000 residents means that there should be at least 3 House of Delegate seats that are almost entirely in Arlington. But currently, only 2 House of Delegate members actually live in Arlington, one in North Arlington and one in South Arlington. The fact that these maps draw both of them into one district shows a lack of understanding and regard for the fact that they live and represent 2 different communities. As a resident of the Columbia Pike Corridor, I urge you to not split up our community and dilute our voice. Please reconsider keeping a House of Delegates seat that is primarily based in the 22204 zip code, which is the most diverse zip code in the entire Commonwealth of Virginia. Please do not divide my community. Thank you.
Thank you, Mr. Stanford, and we appreciate your feedback, and our communications and outreach folks hopefully are capturing this sentiment, and we'll take that into consideration. Our next speaker is Ankit Jain.
Madam Chair, this is Shay. That person is not here.
Okay. Aaron Corbett.
Hi, can you hear me?
Yes. Hi, Aaron.
Hi, nice to see you all again. My name is Erin Corbett. I am the Redistricting Manager at the Virginia Civic Engagement Table. I want to thank you for allowing me the opportunity to speak again. And I wanted to specifically thank Chair Greta Harris for calling attention to during the previous commission meeting in which a series of maps proposed did not distinguish Asian American voters specifically in a table set. So I just thought it would be helpful to add several data points for consideration in regarding making sure that that table is updated. Virginia has added 630,000 people since 2010. Asian American populations have grown 40% in Virginia, adding an additional 174,314 people in the last 10 years. Asian American populations have increased in every single current congressional district, ranging from a 20.66% growth to a 73.5% growth in the last 10 years. Part of what the work that the table does is work with partners that specifically focus on Asian American outreach and AAPI voters. And we would really like to stress how important it is that those tables better reflect AAPI voters instead of simply lumping them into a aggregate minority tab as is currently depicted. So thank you so much for your time. Really appreciate it as always.
Thank you, Aaron. We appreciate your constant comments and feedback. Our next speaker is Peter Evans.
Not here, Madam Chair.
Okay. How about Michael Martin?
Yes, I'm here.
Okay.
Good afternoon.
Thank you,
my
Mr.
name
Martin.
Thank you. Good afternoon. My name is Michael Martin. I live in Fairfax, Virginia, and I want to thank the commission for their time and their effort. I'd like to make 2 requests of the commission. First, please draw one set of maps, not two. And second, as you work to resolve differences, please do so respectfully. As far as one set of maps, there is an advantage to drawing two sets of maps. It's easier to draw a map when everyone agrees, so let's let each side draw separate maps. But there are so many disadvantages. The good features pointed out on one map cannot transfer to the other because they're so different. Improving two maps separately does not converge into the single solution we need. And as a voter evaluating these maps, I don't have 100 House districts to look at, I have 200. And I don't have 40 Senate districts to look at, I have 80. As an analogy, if my wife and I wanted to buy a vehicle, and she likes a Chevy sedan and I like a John Deere tractor, we can't converge the two. You can't put a 6-foot tire on a sedan, and you can't seat 5 people comfortably in a tractor. It just makes no sense and pushes the problem down the road. Last session, when one of the map makers assured the commission that they could do whatever you wanted, well, please ask them, give them direction, and ask them to draw one set of maps so that we can see what's going to finally happen and we converge on a solution. Is that going to be easy? No. But is it necessary? You know it is. And finally, it's now time to resolve the differences. The sausage has got to start getting made in public, and that's not going to be easy. I understand that. There are lots of opinions, good opinions, but they differ and disagree. Please do so respectfully. We've done so good a job. Very little rancor has come out, and the co-chairs have shut it down. Thank you for that. Please respect each other and respect the differences. Thank you for all the work you do. Thanks very much.
Thank you very much for your comments. We appreciate them. And with that, I think we are meeting again on Wednesday of this week at 8. Is it right? Wednesday at 8? Okay. And then next Monday at 1 p.m. So eat your Wheaties. It's starting to get fun, and I appreciate everyone's contribution. Thank you. Have a great day.